All right, good morning, everybody. My name is Judge Kim Teresa Malika. We're here today in First Appearance Magistrate Court. Today you're going to be informed of the charges and we're going to determine if there's probable cause. Today is not your trial day. Please, please, please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. Anything you say or do can and will be used against you. Who do we have at the main jail, Mr. Reedy? We have Mr. Good morning, Mr. Romero.
Good morning, Judge.
Hi, just wanted to make sure it was you.
No problem.
All right, so we have Mr. Romero from the Public Defender's Office at the main jail, and we have Mr. Reedy to my right in the courtroom, who's also from the Public Defender's Office. We have Assistant State Attorney Eric Linder, who's also with us in the courtroom. First case we're going to call is Worley Pinto, please. Worley Pinto, step up, please. Good morning,
Your
Mr.
present,
Pinto.
Judge, I may.
Thank you. Mr. Pinto, good morning, sir. You have an out-of-state hold for a felony out of Massachusetts. You're going to be held no bond. It's for robbery, strong-arm robbery, or strong-armed rape, it says. So court's going to hold you no bond. We'll see you in extradition court Tuesday or Thursday at 1 o'clock, sir. Good luck to you. Lena Sullivan. That's an M.O. Next one's an M.O. Next one's an M.O. Cordacia McCullough, please. Is that North Broward? Cordacia McCullough.
She's here present, Judge, I mean. She's approaching. Come on,
All
okay?
right, thank you, Mr. Romero.
No problem, sir.
All right, Ms. McCullough, you have robbery, no firearm or weapon. The court does find probable cause. This is a capias, not in custody, for a juvenile. It's pending before Judge Usan. You have a no bond hold. What say you, State?
Your Honor, I'm going to be requesting, well, first I'm going to be requesting no victim contact with the alleged victim whose initials are DH.
Okay,
Your Honor, I'm going to be requesting a $10,000 bond. In addition to this case where there's alleged violence that Ms. McCullough and two co-defendants attacked another juvenile and then stole his phone, she is pled out to this year out of Palm Beach County, burglary of a dwelling, theft, attempted burglary of a dwelling, possession of burglary tools, and fraudulent use of personal identification information.
okay. What about no return to Carter Park?
Yes, please, Judge.
Thank you. All right, so I'm sorry, you're requesting how much in bond?
$10,000.
What say you, defense?
Judge, I realize, as you said, this is not in custody capias. When was the alleged date of incident on this offense?
December 26, 2017, it appears to be.
Yes.
Thank you, Judge. That's what I
welcome.
was thinking, Mr. McCollum. This is an incident which allegedly happened last year. Judge, she's 18 years old. She's been residing in our community her whole entire life. At this time, she is going to school. She's attending Whittam Rogers. She's a senior. She lives locally here in Fort Lauderdale with her father. Been residing at the same residence for about 2 years. Her father is the person that she's going to be relying on to post her monetary bond. As far as what the state suggests, as far as the $10,000, it's something that her father is just simply not going to be able to afford. What he does is basically, he does barbecue, and that's not going to be something that he can afford. Judge, the allegations are serious, but it's back from 2017. I do understand what the state's saying as far as her history, so that's why I'm asking for a bond of $2,000 plus pretrial release, so that she could be supervised. But I would like her to basically fight these allegations on the outside rather than here in custody.
State, who are the co-defendants?
One moment, Judge. Cordacia McCullough. Wait, I'm sorry, one moment, Your Honor. Yeah, no, I know.
Latorkai.
Christine O'Neill and Latorkia Mallory.
Are they on today's docket as well?
No.
Okay. Anything further from anybody?
No, Judge.
No return to Carter Park, ma'am. No direct contact, direct or indirect, with the alleged victim with the initial DH, and I want you to maintain 500 feet minimum. I want you to maintain 500 feet minimum from Carter Park. GPS level 2. No co-defendant contact with LaTorkia Mallory and Christine O'Neill. Court's going to do your bond at $5,000, ma'am. Thank you very much. Good luck to you. Next one is Shauna Linland, please.
She's here, President Main, Judge. She's approaching.
Thank you.
What's the bond?
Good morning, Ms. Linland. You have grand theft between $300 and $5,000. The court does find probable cause. The court's going to order no return to the Home Depot located at 3401 Oakwood Boulevard, Hollywood, Florida. Bond set at $1,000. What say you, defense?
Judge, at this time, we're going to be asking for the court to sign an order allowing her access to her phone contacts. She believes that somebody may be able to post her bond, Judge.
Okay. No problem. I'll sign an order.
Thank you, Judge.
Dangerous, Janice Berry, please.
Ms. Berry is in North Broward, Your Honor.
Sure, thank you. All right. Good morning, Miss Berry. You have driving while license is suspended. Third or subsequent offense, they're charging you with a felony, $750 bond. You do have an expired tag, less than 6 months. It's actually not for magistrate, and it's not a criminal offense. Court does find probable cause.
Your Honor, Ms. Berry indicates to me that OZ Bail Bonds is in the process of posting her bond. Apparently, they do not show up in the office until 9 o'clock.
so
So
if there's a
I'm gonna have
problem,
to
just-
call them back.
That's fine. Just reset it for this afternoon, no problem. If there's a change. Thank you, ma'am. We'll leave the bond in place. If you can't bond out, we'll bring you back. Allison Kenny, please. Allison Kenny.
She's coming, Your Honor.
No. They'll let me know. We'll just recall it. Thank you, though, for asking. I'm sorry.
Kenny,
Hello, Miss Kinney. You have petty theft, second degree, third subsequent offense. So even though it's a misdemeanor, they're charging it as a felony. Court does find probable cause. Court's gonna order no return, ma'am, to the Walmart located at 2300 West Atlantic Boulevard in Pompano Beach. If you go back there, ma'am, you will be arrested. What say you, defense?
I'm gonna be asking for pretrial release on Ms. Kenny. I don't know if the state objects.
I don't.
All right, ma'am, we're gonna put you on what's called standard pretrial supervision, which means a bond is not gonna be required in your case. However, you're gonna have certain obligations. You have to report. The deputy will hand you a map now. You have to report within 24 hours of being released. You have to call in twice a week, and you have to report one time a month in person. You don't have to report after court, but if you don't follow that and show up in 24 hours, keep in mind, I don't know what time you're gonna get out today. They close at 5 o'clock, so you have to get there before. It's by the main jail, and you're in North Broward. So if not, then you have to report you're closed on Monday, Ms. Patrice? All right, so 24 hours of your release, then you'll have to report by Tuesday, 12 noon, because they're closed Saturday, Sunday, and Monday's Veterans Day. It's a legal holiday. Okay? Good luck to you, ma'am.
Thank you.
You're welcome. I made sure I stamped it for you, Sheila. Alexis Kubiski.
What's this?
Judge, according to docket, medical loan.
Okay. Adrian Cypress, please.
North Broadway.
Thank you. Good morning, Ms. Cypress. You have possession of Alprazolam Xanax, $1,000 bond. Count 2 is a capious felony. It's actually not for magistrate. You have a no bond hold. You are going before your division judge, who is Judge Michelle Tobin Singer.
Your Honor,
On Tuesday at 8:30 a.m., court finds probable cause. Court's going to leave the bond at $1,000. Thank you, ma'am.
Your Honor, Ms. Cypress is represented by Guy Seligman. I spoke with him earlier. He said he would be here as soon as he could. He's in front of Judge McCarthy right now.
All right, so we'll recall. If you could let me know when I call a case if there's a private attorney. That's okay, I understand. Ma'am, we're waiting for your attorney, okay? He knows to come here? Okay, he knows to come here. Thank you, ma'am. We'll see you in a bit. Renee Keys, please?
North Broadway.
Sure. Good morning, Ms. Keys. How are you?
All right.
Okay, you have, let's see. Robbery, no firearm or weapon. We need to talk about bond. Count 2 is drug paraphernalia, possess and/or use, $100 bond. Count 3, resisting an officer, obstructing without violence, $100 bond. Count 4 is abuse of the elderly or disabled adult without great harm. And count 5 is a capious misdemeanor with a $250 bond. That's for a battery issued by Judge Fishman, capious summons. You are going before Judge Cole on Tuesday, because Monday's a holiday, on the capious misdemeanor for the $250 bond on Monday. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim with the initials JMM. And I want you to maintain 1,000 feet minimum. I also want no return to 951 Northwest 27th Avenue, and that is in Fort Lauderdale. And I want you to maintain 1,000 feet from that residence, minimum. What say you, State?
Your Honor, on count 1, I'm going to be requesting a $15,000 bond. On count 4, a $2,500 bond. First off, obviously, my concern is the allegations that she attacked and robbed a physically disabled person that was wheelchair bound, pushing her from her wheelchair to the ground, and all for stealing $8 from her. Her criminal history: she just was pled out August of this year, theft and resisting without violence. She was also, there were capiouses at that time. In May, another theft, resisting without violence. She was arrested February of this year for false ID, resisting without violence, probation violation on 3 possession of cocaine cases. There was also a violation of pretrial warrant issued in one of those cases. Additional priors include, I mentioned the possessions of cocaine in 2014, 09 escape, burglary of a dwelling, possession of cocaine, resisting with violence. She violated probation, was sentenced to a year in a day state prison. 08 possession of cocaine, 07 resisting without violence. Court.
What say you, defense?
Your Honor, I know Ms. Keys is not going to be able to make the bond requested by the state. She has been a resident of Florida for 15 years. She's been living in the same location for 5 years with friends. She does have a disability that prevents her from working, therefore she has been unable to save up any money on her own that would enable her to post bond. She did give me the phone number of a friend of hers who she believes may be able to come up with some money for bond, but certainly not the amounts requested by the state. I'd request a lower bond with a condition of pretrial release.
All right, the court does have concern for the nature and probability of danger which the defendant's release poses to the community.
She's next.
Court's gonna set bond on count 1 at 15,000, counts 2 and 3, $1 each, count 4, 7,500. We'll leave the capias in place. You can go before Judge Poll. I don't know if she's gonna resolve that then. For the capias misdemeanor, no victim contact, direct or indirect with JMM, and maintain 1,000 feet minimum, no return to the 951 Northwest 27th Avenue, 1,000 feet minimum, GPS level 2. No, you're not allowed to if you're a convicted felon, but I'm gonna say it anyway, no possession of any firearms, ammunition, or weapons. Thank you, ma'am, good luck to you. Shamaya DeFrand, I'm sorry.
Present Judge at Maine, she is approaching.
And she has family here as well, Judge.
Good morning. Good morning. Can you talk into the microphone, please?
Good morning.
Good morning. What is your first and last name?
Darlene DeFran.
And your relationship with Shamaya?
She's my daughter.
Okay. All right, and who's standing next to you? What's your name?
This is her best friend.
Jadis Cosby,
Spell your last name?
Cosby.
All right, thank you. All right, so Mr. Frand, you're charged with burglary with assault or battery. You have a no bond hold. You have criminal mischief between $200 and $1,000, first offense. Court does find probable cause. Court's gonna order no victim contact, direct or indirect, with the alleged victim with the initials YV, and I want you to maintain 1,000 feet minimum. What say you, State?
Your Honor, I'm going to be seeking a no bond hold on this punishable by life offense upon a finding of proof evident or presumption great. Your Honor, I would note that the allegations do support the elements of burglary with a battery. As far as the strength of the evidence, the victim provided a sworn statement, and two witnesses provided sworn statements corroborating the victim's account of the incident. To advise the court why I'm seeking a no bond hold, because I would acknowledge Mr. Fran does not have a criminal history. I spoke with the alleged victim this morning, and she provided me with some additional information. She's in fear for her safety and her family's safety.
They're lying. Judge, she never got in trouble. Your Honor, she's never.
All right, ma'am, I can't have your disruption. I am gonna give you an opportunity to speak. So please, we need you just to refrain from saying anything. We'll allow the state to go, the defense will go, and then I'll give you an opportunity.
Yes, ma'am.
Okay?
And I want the court to be aware, how this all started is that Ms. Voltaire let Ms. DeFran's mother, the woman who just called her a liar, stay at her home with her children when she had no place else to go. She was supposed to stay there for 2 weeks.
Who's she?
Ms. DeFran's mother.
Okay,
She was supposed to stay there for 2 weeks with her children. Ms. Voltaire has children of her own, frankly, a full house. And when the 2 weeks came, she couldn't stay there anymore, and she had to leave. And it appears there's some hurt feelings about that because Ms. Voltaire doesn't directly know Shamaya DeFran. They go to the same church. Yesterday, there was some sort of issue between Ms. DeFran and Ms. Voltaire's sister. Ms. DeFran showed up at her house wanting to fight her sister. Ms. Voltaire said she wasn't there. She had to leave. She had to get off her property. Ms. Voltaire said, "I've got to go get my kids now." And she went to her car, and that's when this happened. Additionally, one of the reasons she's concerned is she advised me, Ms. DeFran threatened her, "When I'm done with your sister, I'm coming after you." She was brought to the emergency room last night, Ms. Voltaire. The emergency room determined they had to have a CT scan. Fortunately, there's no significant damage. At this point, it's just very bad bruising along her forehead where she was struck. But they did advise her, if you are still in pain, she's in pain right now. If you're still in pain for a few days, you should see your doctor. She does clearly this woman knows where she lives. Because as she advised me, she's had no interactions with her. There was no reason for her to be at her house, but she knows where she lives. So she is concerned going forward for her safety, her family's safety. So the court's aware, she advised me the two witnesses that are referred to are her brother and her 16-year-old son.
who's her?
Ms. Voltaire.
Okay, thank you. All right, Mr. Reedy, and then I'll give you an opportunity.
Judge, the only thing I'd point out is that this is and then I'll turn it over to Mr. Romero, but obviously, Mr. Fran does have support in the community, and this is a burglary of a conveyance. I'm not minimalizing it, but it's not a burglary of a dwelling. So I'd ask the court to keep that into consideration. And of course, as always, there are two sides to every story, and as many times happens here in magistrate court, we're only presented with one of them.
All right, ma'am, is there anything you'd like to say?
Yes, ma'am. My daughter never, they called her. She never went over there. Yes, they gave me a place to stay. I have not been over there, but
All right, let me have you raise your right hand. Do you swear and/or, your right hand? Do you swear and/or affirm to tell the truth?
yes, ma'am.
Put your hand down, state your first and last name.
Darlene DeFrand,
Spell your last name.
DEFRAND.
Okay, go ahead.
My daughter went on a trip with her school. When she came back, she got a
your
phone,
daughter?
Shemai DeFrant. She got a phone call from Yolanda Veltar's brother stating that the sister needed to speak to her. And they told her to come over, not to get into no altercation, just to come over and talk. And then she proceeded to call me and let me know that they got into something. I came over there and asked them why, if I put the pastor to be in the middle of the families, why was there a problem where you hit and she hit? But my daughter never went over there. My daughter's been working for a year and a half. She's a senior. She's doing good. This is her first incident. She's not going to go over there. As of her going through all of this, she's not going to go over there, Your Honor. I just wanted her to, as you can see, she's a good kid. She's never gotten in trouble. And the brother that he's stating was just talking to me late last night at midnight. He's caught in the middle because he loves my family. He also goes with the best friend. Did she tell you that part? And my daughter is staying at the best friend's house. So they're still in Iraq with each other. So if my daughter's a threat to them, they're all lying. And all I'm going to tell you is, Your Honor, I just had a baby. She's the one that's been holding this family down. She's the one that got me out of this situation. When she see the lady threw me out, I'm just saying, can she just be released and come to court? Do what she have to do to get past this situation? I know she's sorry. We're sorry. Can she just be put? Just come home. Last night I haven't slept. I haven't eaten since this situation happened. My daughter's not a troublemaker. I got the school will vouch. This is the first incident. I'm so sorry, Your Honor. I'm so sorry it resolved to us having to come like this to you.
Thank you, ma'am. All right, anybody want to respond to proof evident presumption grade? Mr. Reedy, do you have anything further with regard to proof evident presumption grade, or Mr. Romero?
No, Your Honor.
Sure. Judge, the only thing I would wish to say is if the court finds proof evident presumption great, as you are aware, Judge, this court does have the discretion to give reasonable release conditions on Mr. Fran's behalf. I think they're warranted in this situation. We've heard from basically the state confirming that she has no prior record, no prior contact with the system. She's 20 years old. She's been residing here her whole entire life. This is where she grew up. This is where her family is, her friends. She is a senior. She's going to Dave Thomas High School. She wants to go to college, Judge. She's right now been working at the same place for about a year and a half, Dunkin' Donuts, helping her family. She's been making $8.67 an hour. Judge, I'm just asking you at this time to exercise your court's discretion.
Okay, I've reviewed the probable cause affidavit filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, ma'am, on the burglary with assault or battery, you are going to be held no bond until further order of the court. This order is without prejudice, ma'am, for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. On the count 2, the criminal mischief, what say you, State?
Your Honor, if there's no bond attached, I'm not asking for any bond to be attached on count 2.
Okay, no, well, I'm gonna put $100 bond. Court's gonna order no victim contact on count 2, direct or indirect with YU, and maintain 1,000 feet minimum. No return to 8221 Northwest 51st Court, Lauderhill, Florida, and I want you to maintain 1,000 feet minimum at all times. GPS level 2 on count 2. Thank you, ma'am. Good luck to you. Good luck. Rose Height,
She's here, present, Main Judge.
okay, Miss Height, good morning. You have a violation of parole. You have a no bond hold. The parole board will come and see you shortly, ma'am. Thank you. Good luck to you. Next one is Miriam Lucian.
She's here, present, Judge at Main. She's approaching, and she declined the services of public defender.
Okay. Good morning, Ms. Lucian. You understand if you can't afford an attorney, the court will appoint a public defender for purposes of magistrate court today. Do you still want to represent yourself? Do you want me to appoint the public defender? You'll have to fill out an application. Or do you want to, or do you have a private attorney?
Yeah, I'm gonna try to get a private attorney.
Okay, so for
But
purpose,
you
so
only
for
have a
purpose,
bond.
okay, hold on. So for purposes of today, do you want to go forward or do you want me to continue this hearing so you can get a private attorney?
Let me have the private defender right now.
Okay.
Mr. Martin.
One moment, please, Judge. Judge, I'm speaking to Ms. Lucian right now. We're ready to proceed.
All right, Ms. Lucian, you have driving while license is suspended, habitual, so it's a felony, $750 bond. Court does find probable cause. Do we have a driving record on Ms. Lucian?
Judge, while the court's getting that information, would also someone look up to see if her bond's been posted? That's what she's relying on, that her bond may have already been posted, or will be shortly.
No. So if not, then just let me know and we can address it this afternoon. You can look into it, okay?
Thank you, Judge.
$750. Good luck to you, ma'am. Here you go. Wendy Riley, please. Sure.
Hold on, Your Honor.
All right. Good morning. Are you Wendy Riley?
Good morning, Your Honor. Yes, I am Wendy A. Riley.
All right, you have count 5 and 6 are change of charge to an assault of a Leo and battery. Bond set at, it's actually ROR on the 2 capious felonies. Count 4, so it's 5 and 6 I just told you. 4 is assault a law enforcement officer, $1,000 bond pretrial with electronic monitoring
Yes, ma'am.
by Judge Edward Merrigan. Court finds probable cause. What say you?
Your Honor, it's a change of charge. It's actually a down file. I believe Your Honor found no PC originally and ROR'd her, so
Okay.
I don't have on count charge 4, I don't have a problem with ROR, back to where it was.
Well, what about the $1,000 bond?
That's what I'm saying, on that count, it was, you originally,
Says pretrial release with Elmo.
well, that's on other counts. I don't know if it was placed on that count as well.
It's on there.
No, I know it's there. What I'm saying is, I don't know if it was originally put on that count. It was definitely put on, one moment, Your Honor.
Judge, you gave her pretrial Elmo yesterday, and you charged her with aggravated assault, no violence required. Because of the COC, announced a new charge, the 1,000 went back on that charge.
All right, so you want me to take the 1,000 off and keep her on the Elmo state, or what is it?
I'm sorry? I'm fine with just the ROR and keeping her. If you ordered her to pretrial Elmo the other day, then I'd ask that stay on, but I'm not asking for any more bond to be
Well, I'm
posted.
asking you, is that what it is? Because I don't know. You can tell me. I don't remember.
Well, I'm being told, I guess, that you did something the other day when I wasn't here.
All right, so Sheila, what is it that's, I have the count 4, it says 5 and 6, and then it's handwritten in assault Leo, 1,000 pretrial release with Elmo. So before that, what was the assault on the law enforcement officer?
You didn't require a bond, you just gave her pretrial GPS on that.
GPS level 2 or open schedule, do you know? All right, so let's do that. That's what I gave her. So ROR on 5, 6, and count 4, pretrial release, no bond required with a GPS open schedule. Thank you, ma'am. Good luck to you.
I have Your Honor, I have to give the address to pretrial, and I don't know how to do that. I just got, granted.
What's the address? Pretrial's here, they'll take it down.
Okay, it's called the Healing House for Women. And the address is 2491 Southwest 64th Avenue in Miramar, Florida. 33023. The owner is Ashley, Ashley.
You might want to take this down because I think you need to do an order, Mr. Reedy.
And her phone number is area code 954. It is 789.
What's the name again?
789-954-789.
5523. Her name is Ashley, and it is the Healing House for Women. And she's already spoken to my brother and accepted me coming in there. My brother is Doug Garrison. He's on my behalf, my
All right,
stepbrother.
what is the address of the healing place?
It's 2491 Southwest 64th Avenue. It is in Miramar, and I have a zip code of 33023.
And it's Ashley? And what's the full
Yes,
number
it
over
is.
there again, Wendy?
It is area code 954, and then it is 789 5523.
Okay, I got it.
Okay, great.
All right, we'll do an order, ma'am. Thank you.
Thank you, Your Honor.
You're
Have a blessed day.
You too. Kendrick Roberts. All Ryan. Mr. Roberts, good morning, sir. You have false ID given to a law enforcement officer. This is an ad charge. Count 9. Court finds probable cause. Bond set at 100. Court will set the bond at $1 or ROR. What's your preference, Mr. Reedy?
Dollar, Your Honor, Mr. Roberts has some no bond holds.
All right, thank you.
Thank
Bernard, you're welcome. Bernard Hawkins, please.
He's here at Main, Judge. Have a seat. Thank you, sir.
Mr. Garcia?
Bernard Hawkins, please.
He's here at Main.
Thank you. Mr. Hawkins, you have a KBS misdemeanor, $500 bond. It's for possession of cannabis, 20 grams or less. No show at arraignment. Does he want to resolve it?
He does, Judge.
Okay. State what's your offer?
Withhold court costs, Judge.
Withhold and court costs.
He wishes to accept the state's offer.
Raise your right hand. Do you swear and/or affirm to tell the truth, sir?
Yes, I do.
All right, put your hand down. It's my understanding, Mr. Hawkins, you want to give up your right to a trial?
Yeah.
Yeah or yes?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
How do you want to plead to possession of marijuana under 20 grams? Guilty, not guilty, no contest?
No contest.
You've had enough of time to talk to your attorney, Mr. Romero?
Yes.
All right, court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Withhold court costs of $308, 6 months to pay, partial payments accepted. Court takes judicial notice of time served in the Broward County Jail. You have 30 days to appeal the sentence of the court, sir. If you can't afford an attorney, one will be appointed. Thank you, good luck to you.
Good luck, sir.
Another MO. Next one is, and I'm skipping the MOs, I'm not gonna call them.
Thank you.
All right, so Mr. Seligman, come on, step up, nice to see you.
Likewise, Judge, I'm here on behalf of Adrienne Cypress, who was brought before our magistrate docket, and Your Honor was kind enough to roll her till we got here.
Okay, so where is Adrienne Cypress? Adrienne Cypress, does anybody know where she is?
Adrienne Cypress, are you here? Adrienne Cypress?
North Broward. North Broward, do you have Adrian Cypress, please?
She's coming up.
Thank you, sir. Okay, good morning, ma'am. Do you see your attorney?
Yes.
Okay. All right, so Ms. Cypress, you have possession of El Prazolam's Annex $1,000 bond. Count 2 is a capious felony. It's a no bond hold for magistrate. You are going before your division judge, Judge Michelle Tobin Singer, on Tuesday, because Monday's a holiday, Veterans Day, at 8:30 a.m. Judge Tobin Singer also issued a no bond hold. You were no show at a status report August 23rd. Court finds probable cause. What say you, Mr. Seligman, with regard
Judge,
to?
I wanted to be able to see if any bond could be appropriate for this young lady. I see bond's been set in count 1 for the possession. I'd ask the court to consider releasing her on reasonable bail. However, I do notice there is a no bond notice coming from Judge Tobin Singer's office.
Yeah, and it's actually not for magistrate, so.
Correct. It even says not for magistrate on it, so.
Yeah,
Understood, Judge. We have to make the argument anyways.
I understand and I appreciate it. So, with regard to the $1,000 bond, I'll leave that in place. And you'll see Judge Tobin Singer on Tuesday. Thank you, ma'am. Good luck to you. Nice to see you, Mr. Seligman.
Thank you, Your Honor. Call is collect, Adrian.
If you want, sir, you can call North Broward and speak to her for a moment. Just saying if you wanted to. All right, so Deputy, can, the lady that just went, can they speak to her?
Of course,
Make
yes.
sure she doesn't go back. They're calling now.
Okay.
Thank you. To Corey Brown, please.
Is it Corey Brown? He's approaching, Judge. He's here at me.
What? Do you know the extension? It's not gonna ring. Tell them you'll call them. Hold on a second. What's your client's name? Okay, what is the issue with Adrian Cypress speaking to? Is Mr. Reedy, are you on the phone with North Broward?
She's coming out right now. She went back in the seller's room. She's coming out to the phone right now.
Okay, all right, so her attorney's waiting. Thank you, Deputy, for accommodating us.
No problem.
All right, so to Corey Brown, you're at the main jail. Good morning,
Correct.
sir. You have resisting an officer without violent or obstructing without violence, $100 bond. Count 2 is trespass, occupied structure, or conveyance. No bond required. Court is going to order no return to the Parkside Commons located at 901 Northwest 8th Avenue in Pompano Beach. What say you, defense?
Judge, in speaking with Mr. Brown, he wishes to ask the court if you would consider resolving this matter today.
Your Honor, frankly, I don't have an offer at this time. Based on the allegations that Mr. Brown was.
Hold on one moment. Did you get to speak to her? I did. Okay. Oh, thank you. Go ahead, I'm sorry.
It's
Mr.
okay.
Winter.
Based on the allegations that Mr. Brown first was attempting to push the officer down a concrete stairwell, and then I don't know at this time how it happened, but that the officer received 2 small puncture wounds on both his thumbs trying to apprehend Mr. Brown. I really need some more information before I can make an offer, so.
All right, so court does agree with the state. What say you with regard to bond?
Judge, in speaking with Mr. Brown, unfortunately, he's financially indigent. He is homeless at this time. He has a mailing address. He will be coming to court. Judge, I'd ask the court to consider releasing Mr. Brown ROR.
I won't release him ROR based on the facts stated in the probable cause affidavit that the officer obtained 2 small puncture wounds. However, I will put him on standard pretrial supervision and require him to report within 24 hours of his release. I want him calling in 4 times a week, reporting once a month in person. And Mr. Brown, if you don't report within 24 hours of your release, or comply with any of the other terms and conditions that pretrial services instructs you, just gonna end up in jail again. I heard that you said that he was homeless, and that's what it indicates in the probable cause affidavit. Would he like to avail himself of the CRC and try to find a place to live?
Let me ask him, Judge, maybe a good idea.
Your Honor, while Mr. Romero's talking, I apologize. Did the court already order no return to, I believe it's Parkside Commons?
I believe I said that, but I'll say it again.
No,
Not a problem.
it's on me if I missed it.
Almost positive I did. Did I, Ms. Patrice? All right, so I'll say it again. It's no big deal.
Parkside
Yes,
Commons
it's
Apartments.
located at 901, I'm pretty sure I said it, Northwest 8th Ave, Pompano Beach. Parkside, one word, Commons, Commons.
Judge, in speaking with Mr. Brown, he would appreciate that assistance.
Okay, so can someone instruct him before 8 PM tonight? All right, we need an order on to Carrie Brown. Mr. Reedy? CRC, 9 PM tonight. Standard pretrial, no bond required.
Good luck, sir.
Okay? Sir, hold on.
Oh, one more,
Okay.
sir.
Sir, no return to the Parkside Commons, okay? Thank you.
Thank you.
All right, Jason Pennell, please.
Medical reset, Judge, I've been advised.
All right, where is he?
Maine.
David Stevens, please.
North Broward.
Thank you.
Stevens would like to resolve this today if possible.
Where was Shauna Lindland?
Someone got told to pull up.
Okay.
I think it's.
Do we need to write something special in this order, Mr. Reedy?
On which order is that, Judge?
Shauna Lindland, the phone order.
No, I think she's in the main jail, so I think that she
Okay.
should be able to get to her phone in time.
Thank you.
Good morning, Judge.
Good morning, sir. You're charged with trespass after warning, structure or conveyance. Bond is set at $100. Court finds probable cause. Court is going to order no return to a 7-Eleven located at 1500 State Road 84, Fort Lauderdale, Florida. Court does find probable cause. What say you, Mr. Reedy?
Mr. Stevens would like to resolve this today if possible. He's also interested in going to the CRC.
Okay, state.
Offered be time served.
Okay, sir, raise your right hand for me, please. Do you swear, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am, I do.
All right, your name is David Charles Stevens, Stevens?
That's correct.
All right, Mr. Stevens, it's my understanding that you want to resolve your case today and give up all your rights to a trial? Meaning you don't want
Well,
to.
we haven't even discussed the details of the case. I mean, technically, I didn't feel like I was trespassing, so I was gonna plead not guilty, but I would like to resolve this case today. I don't wanna just sit in jail, and the CRC sounds like something I'd be very interested in, so I can get off the street. So I'm not exactly sure how I'm pleading here, but I would like the best
This is how
resolution.
it works, sir.
Back, I need it back.
You can either admit to the charge today and plead guilty or no contest, or if you want to come back to court today, then you can come back and fight your case and have your day in court. It's that simple. I'm not gonna,
Now,
I'm gonna.
if I
I'm not
decide to
gonna-
come back and fight the case, would I still be eligible for CRC?
Yes.
I would still be able
The
to go
CRC
there.
has nothing to do with what you're doing with your case today. And also, I would release you, I would require no bond. I'd either put you on pretrial release, depending on your prior history,
Yes,
or
ma'am.
I'd release you ROR. I don't know that yet. Your attorney, Mr. Reedy, in the courtroom indicated that you wanted to resolve your case today.
Is
So,
what Mr. Stevens indicated to me, Judge.
so those are your options, sir. Do you want to fight your case, or do you want to admit to the charge? Doesn't matter to me. Either way, you're getting out of jail today. And you're gonna go to the CRC if you want. That's completely up to you.
Okay, ma'am. At this point, I would like to say I'd like to fight the case. I would like to talk to the attorney about the details. If I can change that later, that would be fine, but, I didn't feel like I was guilty of trespass.
All right, don't talk about the case. This is what the court's gonna do. Court's gonna order no return to the 7-Eleven state. What's his priors?
Hold on one second. Your Honor, the only thing I see,
Do you agree to an ROR or you object?
no, it's fine, Your Honor.
All right, sir, I'm gonna release you on your own recognizance. You're gonna be transported tonight to the centralized receiving center. I think you'll like it. It's completely voluntary and up to you. They'll meet you when you, at the release desk when you're released. They'll pick you up at 9 o'clock. I am gonna order no return though to the 7-Eleven. You can't go back there. No parking lot, no curtilage, no sidewalk, no nothing. Stay away from this place. If you go back there, you'll be arrested, okay?
Yes, ma'am.
All right. So ROR, the other thing is with your court notice, it says at large. Do you have a mailing address?
Yes, ma'am. I have a brother here in Fort Lauderdale. I use his address.
All right, so why don't you give me his address so I can put it on your paperwork? And the clerk will send notice there, and additionally, you can ask the CRC. We'll always help you look it up. Or, that's the centralized receiving center, or you can always go to a public library and go to Broward Clerk, the Clerk of Court's website, and look it up, okay?
Okay, ma'am.
Just keep in mind, you don't show up for court or you don't get the notice in the mail, it's incumbent upon you, or if your address changes, to notify the clerk of court in writing, okay?
Yes, ma'am.
All right, and you can go to any clerk's office. There's one, the main courthouse, there's one in Hollywood, Plantation, and Deerfield. You just don't have to come to the main one. So in any event, give me your new address, sir.
1416 Southwest 30th Street.
30?
30, yes, ma'am. 33.
33 or 30?
30.
Okay.
30.
Okay, 30th Street.
Fort Lauderdale, Florida. 33315.
Is there an apartment number with that, sir?
No, ma'am.
All right, so let me read it back. 1416 Southwest 30th Street, Fort Lauderdale, 33315, correct?
That's correct, yes, ma'am.
All right, thank you, sir. Good luck to you.
Thank you, ma'am.
Shedrick Hines.
Here, Judge at Maine.
Okay. Main jail. Mr. Hines,
Yes.
good morning, sir. You have a capious misdemeanor. This was actually a warrant, a capious issued by me for operating without a valid license. He was a no-show. $100 bond. Does he want to resolve his case today, or does he want to go before Judge Cole on Tuesday?
He wants to resolve the matter today, Judge.
All right, or we could also talk about pretrial release if you.
Offers adjudication, court costs, credit for time served.
Adjudication time served, $293 in court costs, 6 months to pay, partial payments.
He wishes to accept the state's offer, Judge.
Mr. Hines, raise your right hand, please. You swear and/or affirm to tell the truth?
Yes, ma'am.
All right. Mr. Hines, it's my understanding that you wish to resolve your case today and give up all your rights to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
How do you want to plead to operating without a valid license? Guilty, not guilty, no contest?
Contest.
Have you ever been treated for a mental illness?
No, ma'am.
And you've had enough of time to talk to your attorney, Mr. Romero, who's standing next to you?
Yes, ma'am.
All right, court's going to accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Adjudication time served, $293 in court costs, 6 months to pay. Partial payments accepted. You have 30 days to appeal the legality of a sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you.
Good luck, sir.
Kevin Byrne, please. Kevin Scott Byrne, pardon?
Municipal Judge.
Oh, I'm sorry. Sir, just hang on, we'll, be back with you in a little bit, okay?
Have a seat, sir. They're waiting on the city public defender.
All right, so next one is Taiwan Bell.
Mr. Bell is here, President. Come on up, Mr. Bell.
Good morning, Mr. Bell. You have two capiases. Count 2 is ROR, so it's operating without a valid license and failure to register a vehicle. $25 bond on count 1. Court finds probable cause. Does he want to resolve his case today?
He does, Judge.
All right, State, do you have an offer? Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right, put your hand down. Your name is Tawan, T-A-W-A-N, Bell, B-E-L-L.
Yes, ma'am.
That's my understanding. All right. His bond posted. Does he still want to resolve his case?
Let me ask him, Judge.
Let's find out what the state's offer is at least.
That's a good idea, Judge.
It's operating without a valid license and failure to register a vehicle. He has Dick D6 fees. He failed to appear before.
The documented offer, the previous documented offers withhold court costs of both counts.
He wishes to accept the state's offer, Judge.
All right, sir. So your attorney, Mr. Romero, is telling me you want to give up all your rights to a trial?
Yes.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
All right, how do you want to plead to operating without a valid DL and failure to register a vehicle? Guilty, not guilty, no contest.
No contest.
All right, court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Withhold court costs $293, 6 months to pay. Partial payments accepted on count 2. It'll be a withhold of adjudication. Court takes judicial notice of the time that you served in the Broward County Jail. Court will also recall the late fees and D6 fees. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you. No. Mr. Reedy has, the two of them he has to do.
What's that, Judge?
You have 2 CRC orders.
I gave them to the clerk. In fact, I can give them to you if you want. They're right here.
That's okay. All right, if you want to put, I usually put MB or where they are on the bottom so you know. It's up to you. We have a lot of MOs today. Kenroy Powell, please.
Mr. Powell is approaching, Judge. Come on up, sir.
Mr. Powell, good morning, sir. You have resisting an officer, obstructing without violence, $100 bond. You have interfere with school administrative functions. No bond required on that one. Court does find probable cause. What say you, State?
Here, Mr. Romero.
Any special conditions?
Well, Your Honor, I'd be asking for no return to the school.
Okay, what say you, defense?
Judge, Mr. Powell is looking forward to contesting these allegations.
Sure.
He did inform me, Judge, that he has children that attend the school. He's the gentleman that actually picks his kids up from school. If he doesn't pick them up, then basically his kids are gonna be left there waiting at school until he can find some other means. So, Judge, I'd at this time ask you to sort of cater an order allowing him just to go to the school for purposes of picking up his kids and drop them off and pick them up. Judge, having said that, he's been living here in South Florida for 7 years. He's 34 years old. He's the sole provider of his family. He lives in... Oh, I'm sorry. He's been living here since he was 7, not 7 years, since he was 7 years old. Judge, he lives in Opelika. I'm gonna be asking Your Honor to consider an ROR on Mr. Powell or to leave the bond in place.
Well, it has 9057 Miramar, and then it says at large. Where does he,
That is not his address.
They put whatever they wanted to put there.
where do you
Judge,
sleep every
what
night,
he
sir?
advised me, he's living in Opalaka.
They're gonna Opalaka,
What's your mailing address, sir?
13350 North Ashland Road.
Okay, you're gonna have to say it a little slower, because I'm writing it down, it's spelled the street name.
13350 Ashwan AWSAN Road, apartment 216, Opalaka, Florida 33054.
How long have you lived there?
2 years. It's right around the corner from my job.
Mr. Romero, you're telling me he lives in Opalaka, but his kids go to school in Miramar, and I don't have an issue with that. I don't know about the mother or what the arrangements are, but how can he take his kids to school every day then? Not that he can't. He does? All right, what say you, State?
Your Honor, I don't have a problem with that as long as I would ask that the order be that he not enter the school.
All right, so no return to Sea Castle School and no entering the school. In fact, sir, I want you to stay in your car. How old are your children?
6 and 8.
All right, so they can get in the car themselves, correct?
Yeah.
Okay.
But I
so-
have to get out the car to pick them up because they're not car riders. I have to go after them when the bell ring. I have to go over there to get them to bring them back to the car.
What's car riders mean? I don't understand, Mr. Romero.
Car riders is where you go into the little circle and they come and just get in the car and y'all leave.
Why
don't
can't
have
they,
that.
why can't they be car riders?
Because that's a lot of time and gas that I don't have. That line be way around the corner and down the street. It's easier for me to park my car and pick them up and leave. Which is what I try to do.
Your Honor, based on the circumstances, I know that might be easier for him, but based on these circumstances, I would ask that until further order of the court that the children be car riders.
Well, I'm just gonna say he can't enter the school and he has to stay in his car. He can figure it out how he wants to do it that way. So I'll leave the $100 bond in place, no victim contact with, yes?
I'm just trying to get clarification from Mr. Powell to see if this would work. Judge, what I'm gonna ask you, he has no problem as far as going inside the structure of the building of the school, that he'll adhere to the court's order. I'm asking you to cater the order in a way so that he's permitted to be, drop him off and pick him up. He'll be getting out of his car, but he's not physically going inside the building of the school.
It's never inside the building. It's always outside under a tree.
Your Honor, I would ask that the court keep the order in place that he has to remain in the car. There could still be employees out, and imagine, you know, there would be some staff outside, and that's my concern, is that he stay away from any staff members of the school at this
All
point.
right, I'm ordering no return to Sea Castle School and no entering the school. I want him to remain in his car. We'll have to figure it out. Thank you, sir. Good luck to you. $100 bond stays in place. Dwight Davis, please. Dwight Davis, step up, please.
Mr. Davis?
Okay, Mr. Davis, you have a capious misdemeanor. $1,000 bond. This is for operating without a valid license. Court does find probable cause for the capious. What say you, defense?
He wishes to resolve this case, Judge.
State, you have an offer?
Yes, adjudication time served, Judge.
Adjudication, time served, court costs.
He wishes to accept the state's offer, Judge.
Don't forget that order on the D6 late fees, madam. On the D6 late fees, recalling them. Hold on one moment. I'm sorry, what'd you say? Yes, thank you. Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right, is your name Dwight J. Davis, D-A-V-I-S?
Sorry.
You don't have to be sorry, you okay? Want to take a break?
Yeah. No.
Want to get some water?
No, I'm fine, Judge.
Okay.
Thank you.
All right. Okay, so, Mr. Davis, put your hand down. It's my understanding that you want to resolve your case today?
Yes, ma'am.
Give up all your rights to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Did I swear you under oath? I know you had your hand up, but Mr. Romero, just let me make sure. Put up your hand again. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, and all the answers you just gave me were true and correct under oath? Yes?
Yes, ma'am.
All right, put your hand down. All right, Mr. Davis, have you ever been treated for a mental illness?
No, ma'am.
Doing this freely and voluntarily?
Yes, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes, ma'am.
All right. You've had enough of time to talk to your attorney, Mr. Romero?
Yes, ma'am.
How do you want to plead? Guilty, not guilty, no contest to operating without a valid license?
No contest.
You feel that it's in your best interest?
Yes, ma'am.
All right, court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Adjudication time served, $293 in court costs. I'll give you 6 months to pay that. Partial payments are accepted. You have 30 days to appeal the legality of the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. Good luck to you, sir. So you're sending these to me, Ms. Patrice? Huh? Oh, okay, thank you. All right, Tracy Walker, please.
All right.
Paul Ryan.
All right.
All right,
Good morning, ma'am.
good morning, how are you, sir?
All right, ma'am.
All right, you have some ad charges, counts 4, 5, 6, 7, and 8. Burglary, unoccupied dwelling, unarmed, we need to talk about bond. Counts 5, 7, and, oh, I'm sorry, count 5 is grand theft between $300 and $5,000. Count 6 is burglary of a dwelling, structure, or conveyance armed, there's a no bond hold. 7 is grand theft of a firearm, and 8 is a repeat of count 5, grand theft between $300 and $5,000, $1,000 bond. Court does find probable cause. Court's gonna order no victim contact, direct or indirect, with the alleged victim in the case with the initials MG and RJB. And I want you to maintain a minimum of 1,000 feet from these two alleged victims. Do you understand, sir?
Yes, ma'am.
All right. What say you, state?
Excuse me, Your Honor. I'm going to be requesting a $10,000 bond on count 4. I'm not seeking a no bond hold on count 6, but for the PBL armed burglary of a dwelling, I'm requesting a $25,000 bond. Thank you.
Okay. What say you, defense?
Your Honor, Mr. Walker's not going to be able to make those kind of bonds as posted by the state. The evidence against him in these two burglaries appear to be DNA matches on cases that happened some time ago. That being said, he does have a no bond out-of-state hold on count 3. So Mr. Walker is not currently going to be going anyplace until he resolves these matters. I'd ask for a $5,000 bond on count 4 and a $2,500 bond on count 6. No matter what bond you set, Judge, he's not going to be released.
Well, I don't know if something would happen with that charge or whatever, so I'm just gonna base it on these. So, on the burglary, unoccupied dwelling, unarmed, $10,000 bond. Count 5, 1,000 for the no bond hold, first-degree felony. I do agree with the state that a $25,000 bond should be set. 7 and 8 are left at 1,000. No victim contact, direct or indirect, with MG or RJB. No return, sir, to 933 Northwest 45th Street, Deerfield Beach, and 3979 Northwest 9th Avenue, Deerfield Beach. And I want you to maintain 1,000 feet minimum from the victims in this case and from those two addresses. Court also is going to do a GPS level 2. Thank you, sir. Good luck to you.
Yes, ma'am.
Brett Stratton, please.
North Broward.
Sure, thank you.
Good morning, Your Honor.
Good morning, sir. Mr. Stratton, you have an ad charge, count 2, possession of a weapon by a convicted felon. Case is pending before Judge Tim Bailey. This is an ad charge. Court does find probable cause. You are going before your division judge, Tim Bailey, on Tuesday at 8:30 a.m. What say you, State?
Excuse me, Your Honor. I'm going to be requesting a $2,500 bond just so the court can get a picture of the total circumstances here. Count 1 was an aggravated assault. He has a $5,000 bond. The allegation was while in possession of a knife, he threatened the alleged victim that he was going to cut his head off.
Okay, what say you, defense?
I believe Mr. Stratton has a $15,000 bond
I'll
on
check.
count 1, which he's indicated to me he is not going to be able to make under any set of circumstances. I'd ask the court for a $1,500 bond and let him go in front of his division judge, Judge Bailey, on Tuesday.
It's a $5,000 bond.
Okay, 2,500. Thank you, sir. Good luck to you.
Thank
See
you.
Judge Bailey on Tuesday. David Chandler, please. David Chandler,
He's here present, Judge?
Main Jail.
Yes.
All right, Mr. Chandler, good morning, sir. You have some ad charges. You have a warrant for a violation of pretrial for a misdemeanor. That's actually not for magistrate. $1,000 bond's been set. Count 7 is false owner info for pawn items less than $300, $1,000 bond. Count 8 is dealing in stolen property.
Thanks.
Court's gonna order no return to the Holiday Express at 205 North Federal Highway in Dania Beach. Go back there, sir, you will be arrested. What say you? Court finds probable cause.
Judge, I'm trying to ascertain certain information. I know Mr. Chandler's been here a couple of days, and this, according to dockets, like, add 6, 7, and 8.
Yes, sir.
What else is holding him, and what is his bond on the other matters?
He's got a burglary structure, $1,000 bond, felony theft, $750 bond, $1,000 bond, false owner info on a pawn item, $3,500 dealing in stolen property, $1,000 on the pretrial warrant that Your Honor mentioned.
Judge, so if my math's correct, it's gonna be well over $5,000, which is currently holding him. From what Mr. Chandler says, he's basically financially injured, and he can't afford anything. He's asking me to ask the court if you would consider releasing him on pretrial. I do understand count 6 is a violation on pretrial, but right now, Mr. Chandler, unfortunately, is financially injured.
Well, that's actually not for magistrate, just for the record. So court's gonna leave the bonds in place, no return to the Holiday Inn Express. You'll see your division judge on Tuesday. Thank you, sir. Good luck to you. Martin Hanner. Main Jail, Mr. Hanner, good morning, sir. You have possession of cocaine, $1,000 bond. Count 2 is violation of probation. Count 3 is an out-of-county hold for a felony.
Judge, I'm sorry. My mistake, he has a private attorney. What's your private attorney's name, sir?
Melnick.
Mr. Stephen Melnick. I apologize, Judge.
Does Mr. Melnick know that you're here, sir?
Yes.
He said if he didn't pick up to call Earl Tillman or something like that.
All right, what's his number, sir?
I don't know. I don't have my phone on me. I don't know his number, but.
I'm sorry. Oh, okay, no problem. Thank you so much.
I have the number if you want it, Judge.
Sure, and then I'm gonna ask, anybody else have a private attorney that we can call?
There is one I was in the process of calling.
Okay. What's Mr. Melnick's number?
954
Thank you.
462 7234.
Okay, let me see if I can get him on the phone. Yeah, Stephen Melnick, please. This is Judge Malika from Magistrate Court. You're being recorded. You're on.
Hey, Judge, how are you?
Good, and you're
Okay, do
being
you know what page he's
recorded.
on?
Okay.
All right, so we have Martin
Do
Hayner
you know
in
who his
front of
lawyer
us.
is?
Okay.
Do you represent him?
Yes, I do. I've e-filed on all the cases.
All right, so we
that's
need to
on Edwards?
magistrate him, so he has count one, possession of
That's on
cocaine,
Edwards?
$1,000. Count two
Okay,
is a
and where are you?
violation of probation, no bond
Conti, okay,
hold.
great. Okay, Deputy, thanks. I'll give him a call.
We know.
Count three is an out-of-county hold for a felony, $2,500 bond. He is going before Judge Shear on Tuesday, 11/13 at 8:30 a.m. Court finds probable cause.
Okay.
Okay?
Perfect. Tell him I'll see him there on
All right.
Tuesday.
Did you hear that, sir? Thank you. Good luck to you.
Okay, thank you, Your Honor.
Have a great day. Bye-bye.
Okay, bye.
Who's the other person that has a private attorney?
I think it's actually the next case.
Okay, Christopher Brown.
Mr. Scott Hecker.
No, it's actually Sean Hibbert. One more after
All
one
right,
after
so
Mr.
let's
Brown.
go to Christopher Brown.
Mr. Christopher Brown is here.
He's the next case. Okay, Mr. Brown, come on up, sir. You have burglary, unoccupied structure, unarmed, the $5,000 bond. You have grand theft between $300 and $5,000, $1,500 bond. Dealing in stolen property, $1,500 bond. Count four is false owner info. This is from a warrant set by Judge Holmes. Court does find probable cause and adopt Judge Holmes' finding of probable cause. Court is gonna order no return to PTL cabinets and starting over enterprises located at 4120 Northwest 10th Avenue in Oakland Park, Florida. Court's also going to order no return to the Value Pond located at 1000 West Oakland Park Boulevard in Deerfield Beach. Wait a second, sorry. Value Pond, 1000 West Oakland Park Boulevard in Wilton Manors. What say you, defense?
Judge, as being Mr. Brown, he's not going to be able to come up with that monetary amount as far as bond. He's 57 years old, been here for over 15 years in South Florida. And he's, what he does on the side, he basically does roofing whenever he can get work. He can get, on a good week, about $300 a week. Unfortunately, at this time, he is homeless. However, he does have a mailing address. And from what he advised me, he does has prior contact with the system. But I believe the last time was, it's been a couple years. So, Judge, that's why we're asking for the court to consider releasing Mr. Brown on pre-trial release.
I'd like to go to
CRC. And also, he advised me right now, he's been hearing as far, with the course, been extending, he's been hearing information about the CRC and he's interested in that, Judge.
Okay.
Your Honor, I'm going to ask that the court keep the bonds in place. I find it a bit ironic, Mr. Romero mentioning he's having trouble finding steady work and he's looking for assistance from the CRC when he was in a program that the whole point was to help him eventually get steady work. And the allegation is he committed a burglary against this business.
What program?
This business, one moment. According to the affidavit,
Oh, and hiring homeless subjects, yeah.
for the purpose of, provide them hands-on training to maximize the immediate employability of each successful candidate. Yeah, it is true he hasn't been arrested in a couple years, but that's because he's been in state prison. He was in 2013 in Bay County, trafficking stolen property, burglary of a structure. He was sentenced to 4 years state prison, and he was released October 9th of last year. He's also been to state prison for 5 separate burglaries in the past, 3 separate grand thefts, grand theft auto, trafficking in stolen property on 2 occasions as well. And also 8 prior failures to appear.
Anything further?
Not at this time, Judge.
All right, no return to the value pawn and the PTL cabinets and starting over enterprises. Court's gonna leave all the bonds in place. Thank you, sir. Good luck to you.
So,
Is it a felony or MO? Just come up here.
Nobody didn't say on the thing it was gonna snow. It's like,
Oh, don't worry. All right, Sean Hibbert.
He's the gentleman that
Mr.
has,
Scott Hecker represents him, Judge.
Do we have Mr. Hecker's number?
Yes, Judge, it's 954
Okay,
651
okay.
5679.
All right, you're Mr. Hibbert, sir?
Yes, good morning.
Does your attorney, good morning, does your attorney know that you're in, first appearance court, you've been arrested?
I notified my mom last night yesterday before I get arrested, so she notified him.
He's aware, Your
So
Honor.
he should be aware.
He
Hi,
contacted me yesterday.
hi, is this Scott Hecker? Hi, this is Judge Malika, you're on speakerphone, magistrate court. You're welcome.
Good morning, Judge.
So you're being recorded, we have, whoops, hold on. Sorry, I just knocked the phone off the hook by accident. We have a Mr. Sean Hibbert here. Are you representing him?
I represent Mr. Hibbert in a different matter. I do not represent him in this particular case.
All right, do you want to represent him for purposes of magistrate court? Or do you want the public defender? Okay, so, all right.
I will represent him on behalf of Magistrate Court, yes.
All right, so if you could try to talk a little bit louder. Mr. Hibbert, do me a favor, hit the mute button, because I'm getting a lot of feedback from the jail, and I want to make sure your attorney can hear me. If at any time you can't hear me, just undo the button or start waving your hands or something, okay? Thank you. All right, so Mr. Hibbert, you have burglary with assault and/or battery. There's a no bond hold for a magistrate. Court does find probable cause. It's actually a capias not in custody signed by Judge Usan on 2/21/2018. Allegedly occurred December 5th, 2017 at the Hamlet Apartments. Reference to a burglary that just occurred. Mr. Linder, I'll let you maybe enlighten Mr. Hecker so he's not in the dark.
Sure, thank you, Your Honor. And I spoke with Mr. Hecker about this matter yesterday, actually.
Oh, okay.
But we didn't go over the details, but we did speak about it
All right.
briefly. Your Honor, the state is going to be seeking no bond hold on this punishable by life offense upon a finding of proof evident or presumption great by the court for first appearance purposes only. As Your Honor mentioned, this is a filed case. The state has investigated and determined the appropriate charge to file is burglary with a battery. The allegations being that Mr. Hibbert, when visiting the home of the mother of his child, wanted to go in to see the child. The mother at that time was not allowing that. Without permission, he forced entry into the home. There was a physical altercation where he struck the alleged victim. Specifically, the allegation is that he punched her. The allegation is he broke a window to enter the home. This window was located directly by where I believe the crib or where their child was sleeping, but also a child that she has that he's not the father of was also in that location. Your Honor, I would note there was an independent witness that happened to be staying at the victim's home at this time. She provided a statement corroborating the alleged incident that she witnessed. Your Honor, I can advise the court that sworn statements have been taken from both the alleged victim and the witness. And I imagine no matter what the court finds, you're going to be ordering no victim contact. The alleged victim's initials are CS.
All right, so you're seeking a finding of proof, evidence, presumption, great, no bond hold?
Yes, ma'am.
All right, what say you, Mr. Hecker?
Judge, this was an incident we had known about, and I had spoken to Mrs. Woodfine, which is my client's mother, a couple days ago about this, and we believe that there's a waiver of prosecution that this young lady gets filed somewhere. But at this point, Judge, he's going to need a bond hearing, which can't be held in magistrate court. So at this point, I would just let the court set whatever bond or set what no bond the court would like to set, and I'll take it up with Judge Uson.
Yes. All right, so, Mr. Hibbert, I have reviewed the affidavits filed in your case, and I adopt the finding of probable cause, and the court also finds probable cause filed in your case, and I further find the proof of guilt to be evident on this burglary with assault or battery charge, or the presumption great. Therefore, on this charge, you're going to be held no bond pending further order of the court. This order is without prejudice for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. Your attorney is going to file a motion to set bond with your assigned division judge, just as he indicated. Your client's raising his hand, Mr. Hecker.
Exactly.
Mr. Hecker? Mr. Hecker?
Yes, ma'am.
Your client's raising his hand. He wants to say something. What say you?
I don't really think he needs to speak about this case at all at this time. I would direct him not to say anything.
Okay, he'll direct you not to say anything, sir. So the court's going to order no victim contact, direct or indirect, with CS, and even though he's no bond, I'm still going to do 1,000 feet. Thank you, sir. Good luck to you, okay? Your attorney will be in touch with you.
Thank you, Your Honor, for letting me appear by telephone.
No problem, anytime. Nice talking to you. Bye-bye. Richard Scott Forrest, please.
Mr. Forrest is in the North Broward Detention Center. He declined the services of the Public Defender's Office.
Okay, no problem. All right, Mr. Forrest, please. North Broward. Thank you.
Objection, Your Honor. I'm not Richard Scott Forrest. I believe this court has the wrong party.
All right, so what is your name, sir?
I'm a flesh and blood man with the attribute Richard Scott with the surname of Rapkin, R-A-P-K-I-N.
Okay. All right, sir, you have the right to, today, you have the right to remain silent. Anything you say or do can and will be used against you. So let me just finish, sir. I'm going to give you an opportunity to speak. It's my understanding that you decline the services of the public defender, which is fine. You can represent yourself. You can hire a private attorney. What would you like to do, sir?
I'd like to reserve all of my rights. I'd like to challenge the jurisdiction of this court.
Okay.
And federal Supreme Court case law states that once jurisdiction is challenged, it must be proven.
All right,
And that
sir.
jurisdiction can be challenged at any time.
All right, sir, so you're charged with grand theft between $300 and $5,000. $1,000 bond, court does find probable cause.
Objection, Your
Court
Honor.
is going to order no victim contact, direct or indirect, with the alleged victim with the initials AV. And the court is also going to order no return, sir, to the Ritz-Carlton located at 1 North Fort Lauderdale Beach Boulevard in Fort Lauderdale, Florida. And the court wants you to maintain 1,000 feet minimum from the alleged victim and from the Ritz-Carlton in Fort Lauderdale, the address I just mentioned, at all times.
Objection, Your Honor.
What say you, State?
Your Honor, I'm going to be requesting a $10,000 bond. First noting that Mr. Forrest currently has pending charges of
Objection, Your Honor. I'm not Mr. Forrest.
burglary of a conveyance and resisting with
Objection, Your Honor. This court find probable
It's
cause.
overruled, sir. I'll give you your opportunity.
This court has violated my constitutional rights.
Go ahead, Mr. Woodman.
The opportunity.
He has pending charges of burglary of a conveyance and resisting without violence. Since he's had that case pending, he was arrested. One moment. From July of this year, and that was under the name Richard Rapkin for loitering and prowling. where he was seen fleeing from a residential area where a burglary conveyance had just occurred.
Okay.
Additionally, Your Honor, my concern is his future, and he was also arrested on capiases on the felony case at that time. My concern, in addition to the ongoing criminal activity, is his future appearance in court, based on the allegations in this case that he allegedly stole a woman's purse from a conference room at a hotel, and then to avoid being apprehended, went so far as to climb down a maintenance rope from the third-floor terrace of this hotel.
The Ritz-Carlton.
We also, Your Honor, get hits out of Indiana, Missouri, New York, Louisiana, and Kansas.
Okay. All right,
Authority.
go ahead, sir.
And also, I've been violated of my right to due process. I've had not had opportunity to notice, an opportunity to defend. I've been violating my Fourth Amendment right to be secure in my person and papers. Also, my 13th Amendment right to be not compelled to perform any under contract that I have not entered into knowingly, voluntarily, intentionally, and with informed consent. I'm not aware of any contract with any of your corporations. I've not violated any. I haven't had any violations of any of your corporations, considering the fact that I have no contract with any of your corporations. And if any of your corporations do have a contract, would they please submit the contract into the record for the record?
All right, sir. Court's going to order $10,000 bond on count one, no victim contact, direct or indirect with AV, 1,000 feet minimum and no return to the Ritz-Carlton at the address I said, and maintain 1,000 feet minimum, GPS level 2. Thank you, sir. Good luck to you. We're going to go off the record for one moment. Jean Phillip, please. Main jail. Mr. Jean
Yes, Judge.
Phillip, good morning, sir. You have ag assault with a deadly weapon without intent to kill. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim with the initials GJM. And maintain a minimum of 1,000 feet. What say you, state?
One moment, Your Honor. Does this guy have anything outside of Broward? Excuse me. Your Honor, I'm going to be requesting a $5,000 bond. If the court didn't already order it, no firearms, weapons, or ammunition. His history, 2 trespasses this year, 3rd trespass last year, and he went through drug court 2013 for felony possession of controlled substance. It does appear he successfully completed drug court.
Okay, defense?
Judge, $5,000 is something Mr. Jean Philippe doesn't have, nor anyone he knows. 31 years old, been living in South Florida now for over 12 years. He works at a warehouse. He's been working at the same place for about 5 years. Makes about $80 a day. He lives in Lauderdale Lakes, where he lives with the mother of his child and his child, Judge. He's been residing at that place for about 7 years. He believes that the mother of the child can come up with, if the court were inclined to set a $1,000 bond using the services of bondsman, that he could post that monetary bond. As you heard, Judge, he's had few contacts with the criminal justice system. I don't believe anything violent. So what we're asking the court to consider at this time is a $1,000 bond on count one with standard pretrial release.
He did have in 2015 a domestic violence battery arrest that was dropped.
What's the distance? Because I see that one is 3610 Northwest 21st Street and the victim is 3801 Northwest 21st Street.
I'll check that.
I just want to make sure it's not over the 1,000 miles, because I do want to let him, if it's a couple blocks away,
I understand.
live at his residence.
I'll check that right now.
Is that where you live, sir, the 3610?
Yes, ma'am.
Okay, and that's Northwest 21st Street, apartment 207, Lauderdale Lakes?
Yes, ma'am.
Okay.
It's walking distance, just over 1,000 feet. So if you want to do 500 maybe?
Yeah, I'll do 500 feet, so it's not an issue. All right, anything further?
No, Judge.
$2,500 bond, no victim contact, direct or indirect, with CJM, maintain 500 feet minimum. That means no driving by his house, sir. GPS level 2. Thank you, sir. Good luck to you.
Just write GPS level 2 on that, please.
Everybody see there's a, with Dustin or Dustin Nia?
Yes.
Attach 2 orders to that case, right? 2 people? Okay. No, I wanted 2, I didn't download it, I was just trying to multitask. Okay, thank you. Oleg Vank?
I'm advised the Russian interpreter will be here around 10:30, Judge.
Your Honor, if you just want to make a note now in advance, this should just be a grand theft 3rd degree.
Between 300 and 5,000,
Yes, ma'am.
$1,000 bond.
Yes.
Jason Martin?
Mr. Martin is approaching. Come on up, sir.
Good morning, Mr. Martin. You have possession of cocaine, $1,000 bond, Count 2 is pedestrian failed to cross in a crosswalk. It's actually not for magistrate. And you also have a capious felony with a no bond hold, not for magistrate. That's in front of Judge Siegel. You were a no-show. A calendar call, it appears. Court does find probable cause. What say you, defense, with regard to the $1,000 bond?
Nothing at this time, Judge.
Okay, $1,000 bond. You'll see Judge Siegel on Tuesday at 8:30. Good luck, sir. Luis Garcia, let me know when you're ready.
Mr. Garcia is here present, Judge.
All right, main
Come on
jail.
up, sir.
Mr. Garcia, good morning, sir. You have 2 counts of grand theft of a firearm, $1,000 each. Count 3 is use, display, etc. firearm during a felony. We need to talk about bond. Count 4 is possess with intent to sell, manufacture, or deliver cannabis. $1,000 bond. Thank you, Mr. Shade. Oh, awesome. Thank you. Count 3 is user display, etc. firearm during a felony. We need to talk about bond, as I previously said. Count 4 is possession with intent to sell, manufacture, or deliver cannabis, $1,000 bond. 5, possess cannabis over 20 grams, $1,000 bond. 6, possession of cocaine, $1,000 bond. Count 7, the last count is possess and/or use drug paraphernalia, $100 bond. Court does find probable cause. What say you, state, or defend? Yes, state.
Requesting a $2,500 bond on count 3, Judge.
Count 3, any other special conditions?
No possession, firearms, ammunition, weapons.
Okay, what say you, defense?
Judge, my understanding is Mr. Garcia has a clean adult record. He's 20 years old, been here his whole entire life. He works in construction. He gets paid daily and anywhere from $80 to $100 a day. He attended Deerfield Beach High School. He's going to be relying on his father to help post his bond. I believe he works for Waste Management. I'd ask you, Judge, just on count 3, to set a $1,000 bond. Leave counts 1, 2, 3, and 4 the same. That would be a total of $4,000. And I'd ask you to consider ROR 5, 6, and 7. So we're asking for a total of $4,000 on Mr. Garcia's behalf.
What kind of vehicle does your client operate?
Excuse me?
What kind of vehicle does your client
Oh.
operate?
Judge, he doesn't own a vehicle. His father owns a Dodge Challenger.
Okay, I'm gonna leave all the bonds in place except for count 3 is 2,000, count 7 LR, no possession of any firearms, ammunition, or weapons. GPS open schedule. Thank you, sir. Good luck to you.
Your Honor, our Russian interpreter is here.
Perfect. Hello, good morning.
Morning.
Can you raise your right hand for me, please?
Yes.
You swear and/or affirm to translate from English to Russian, Russian to English?
Yes, I do.
State your first and last name and spell
Yes.
your last name.
Yes, my name is Helen Lurye, Lurye, and I'm a certified court interpreter.
Thank you, ma'am.
You're welcome.
All right, so are you Mr. Oleg Vank?
Скажите, вы являетесь мистером Олегом Ванком? Yes.
All right, sir, you're charged with grand theft, 3rd degree,
Вас обвиняют в краже в особо крупных размерах 3-й степени,
between $300 and $5,000.
который от 300 до $3000.
Bond is set at $1,000.
Залог дается в сумме $1000.
Court does find probable cause for your arrest.
И суд считает, что были основания для вашего ареста.
Court's going to order no return to the target.
И суд приказывает не возвращаться больше в таргет.
Located at 16901, 16901.
Который находится по адресу 16901. Номер 16901.
Miramar Parkway,
Мирамар Парквей.
Miramar, Florida.
В Мирамаре, Флорида.
What say you, defense?
Что вы скажете в вашу защиту?
Judge, my understanding is, I believe the court found probable cause for a 3rd-degree felony grand theft. So I believe the standard bond is $1,000. My understanding And speaking, Mr. Vaughn, this is your first time being arrested?
Just got to interpret.
Yes, thank you. Да, значит, адвокат говорит, я так понимаю, что считают, что есть достаточно основания дать ему обвинение в краже в особо крупных размерах третьей степени и залог в $1000.
Having said that, Judge, if he has a clean record, I'd ask the court to consider an ROR or in the alternative, leave the bond $1,000.
Но если у него нет никаких предыдущих судимостей, то я считаю, что вместо того, чтобы дать ему залог $1000, просто выпустить его на собственные поруки.
Can you tell me your client's ties to the community, sir?
Вы можете мне рассказать о том, как ваш клиент связан с общественностью, с местным населением?
He's 53 years old. He's been living here in South Florida for the past 13 years, Judge.
Ему 53 года, и последние 13 лет он живет в Южной Флориде, судья.
He is working right now. He's an Uber driver.
Он работает сейчас, он является водителем Uber.
Financially, he's facing a tough time. He's going through a divorce.
И в финансовом плане у него настали тяжелые времена, сейчас у него развод, он в процессе развода.
He did give me the phone number to his friend that works at a retail store that could potentially post his monetary bond.
Да, и он дал мне номер телефона своего друга, который работает в розничной торговле, который, может быть, даст за него залог.
So, because this is a non-violent offense, his first contact with the system, I'm asking for ROR or in the alternative, leave the $1,000 bond in place.
Да, и так как он первый раз попал в систему, до этого у него не было судимости, я прошу, чтобы его выпустили на собственные поруки, вместо того, чтобы давать ему залог.
Does he own the home at Timber Cove Lane?
Он владеет домом в Timbercombe Lane. I'm sorry, you own?
He rents.
In Weston.
And
Weston.
the monthly rent is $1,800 a month.
Он снимает квартиру, в смысле, снимает этот дом, и в месяц он платит $1800.
Court will order $1,000 bond.
Суд выдает приказ на залог в $1000.
$1,000 bond, no return to target. Thank you.
Да, выйдите под залог по $1000 и не возвращайтесь обратно в этот таргет. Спасибо.
I'll call your friend right after court. Good luck.
Я позвоню вашему другу, потом заполним бумаги.
Thank you.
You're welcome, Your Honor.
Okay.
Sure, no problem.
Thank you so much. Always a pleasure. Have a good day. Wilmeth Hughes, please.
Mr. Hughes is here, President Main Judge.
All right, Mr.
Good morning.
Hughes, good morning. You have distribute, deliver cocaine, $2,500 bond. Count 2 is possession with intent to sell, manufacture, deliver cocaine, $2,500. Tamper with or fabricate physical evidence, $1,000 bond. Court does find probable cause. .9 grams of crack cocaine. What say you, defense?
Judge, the $6,000 is something Mr. Hughes can't afford. We're going to be asking for the court to consider releasing him on pretrial release, and this is why. He's 43 years old. He's been here in South Florida for over 30 years. Right now, he is working. He works like at a labor pool where he gets anywhere from $80 to $100 a day. He does own one piece of property. It's a 2011 Ford Transit with over 100,000 miles on it. It's basically wrecked. It has like some sort of body damage and also in bad condition. So he believes the resale value on that is going to probably be around $1,000. Unfortunately, he is homeless right now. He has mailing address, and that would be of a family friend that resides in Sunrise. But right now, he advised me no one can post his monetary bond. He does have a record, but I believe he's been over 5 years clean, Judge, without contact with the criminal justice system. 9 years. So, Judge, I'm going to be asking the court to consider releasing him on pretrial release.
I'm gonna put him on a GPS, so he's gotta find a place to live. But what's this address? I have an address here of 1960 Northwest 47th Ave, Lauderhill.
What address is that?
My mom had moved from there. I was living, working at an apartment complex doing maintenance. At the time, I had a problem with the
That's
owner.
fine. So what is your mailing address, sir?
It's 6670 Southwest 27th Street, Sunrise, Florida. I was staying there before my sister passed, and then that's what made me homeless. Had to live in hotels and stuff.
Northwest or southwest? I think it's northwest.
Northwest? Northwest. Yes.
Any apartment number?
No, it's a house. My nieces and nephews live there. I can go there.
All right. So what say you, defense? State, I mean.
Your Honor, if the court's inclined to place him on pretrial with the GPS, I don't have an objection to that.
Okay, so no bond required?
I'm fine with that.
Okay, GPS, open schedule. He's got to find a place to live. Thank you, sir. Good luck to you. All right, Mr. Shate.
Yes, Judge. The first matter, Judge, is on page 2, and that is Laura Sullivan. She's at North Broward.
I have Lena. Lena?
Lena Sullivan, Judge. Laura Murray is also mine.
Okay.
Judge, she's got an open container out of Hollywood. She'd like to resolve it today.
Adjudication time served. $78.
That's what I told her.
Is that what you want to do, ma'am?
Yes, ma'am.
Yes, ma'am.
Want to give up your right to a trial?
Yes.
How do you want to plead to open container? Guilty, not guilty, no contest?
No contest.
All right. All right, adjudication time served, $78 in court costs, 6 months to pay. Partial payments accepted. Thank you, ma'am. Good luck to you.
Thank you.
Next person?
Is Laura Murray, Judge. She's also in North Broward.
Okay, North Broward, Laura Murray, please.
Hello.
Hello, ma'am. How are you?
All right, how are you?
Good. All right, so here's the thing. I tried looking up all these cases. She has 18, 1932, 1937, 1938. I can't find any PCs. She has 3 panhandling. Obviously, something's going on here. So she can either wait to see her division judge, which I know it's Tuesday because she has the $350 bonds, or I can put her on standard pretrial, but she's going to keep getting arrested and keep coming back.
Judge, I had suggested
These
that.
are the options. I don't have a probable cause affidavit on here.
Okay. Did you hear that, Laura?
So I can put her on standard pretrial, or can she pay the bonds?
Are you able to afford any bonds, or do you have any family or anybody, friends?
I can try and get the bond, but if I get pretrial, will I be released today?
Yes.
Yes. You'll
But
have to
here's
show
the
up in
catch.
court, though.
Here's the catch. You have to report within 24 hours of your release. So if you get out today, because they're closed on Saturday and Sunday, and Monday's Veterans Day, it's a legal holiday, they're not open. So you either report today, it's at the main jail, by 3 o'clock or 4 o'clock, the latest, or you're gonna have to report by Tuesday noon. If you don't, there'll be a warrant out for your arrest.
Judge, actually, if she wouldn't have to report on Tuesday because she has court on Tuesday morning at 8:30.
No, they're not doing that anymore. If
They're
they're
not gonna-
released,
Okay,
then she just gets a new court date in the mail.
okay.
Yeah.
I'll take the pretrial.
Okay, so standard pretrial, you got the map, report within 24 hours. No return to any of these locations where you were arrested, ma'am.
Okay.
I'm putting you on pretrial on these 3 cases. I want you calling in twice a week, reporting 1 time a month,
And how long is this going to last for?
as long as your cases go on. So let me get your address here. I have 6860 Southwest 120th Street, Pinecrest. Is that where your mail goes?
Yes.
What's the zip code? Because it says 333156.
It's 33156.
That's what I thought. Give me the full address where you want your mail to go to.
6860 Southwest 120th Street, Miami, Florida 33156.
Any apartment number?
No.
All right, so 6860 Southwest 120th Street, Miami, correct?
It's been.
All right. All right, so report within 24 hours, court finds probable cause. Thank you.
Thank you.
Adam Arguda, is that the next one?
Yes, Judge, page 9.
Where's that? Where is he?
He's in main jail, Judge.
Main jail, page 9.
Good morning, Judge.
Good morning. Okay, Mr. Argudo, I'm sorry. You have resisting an officer obstructing without violence, $100 bond. Count 2 is resisting an officer without violence. I remember reading something about this PC. Let me just look it up. Have you read the PC on the regular charge? Here you go, Ms. Patrice. Here's another one. I don't know why they're not doing any of their PCs in here. Or the notice to appears. Let me make a copy of this. So I can't resolve this one either. I don't know why there's no PCs in the file.
Aaron, one of this, the top one is yours on this case. Adam Arguedo, page 10, page 9.
1936, MO 28. This is like all these cases.
Judge, if you look, that's actually one number, it's in between the two Laura cases. So Laura has 1937, and then 1938. This is the one right before it, so maybe there's some issue with that little block.
Argudo.
I don't know, so this is what I can do. I can give them another opportunity, but I'm gonna put them on standard pretrial. Not gonna resolve the cases. I can't if I don't have a warrant. I mean, probable
On
cause
count 1, you don't have
affidavit.
a PC affidavit on count 1?
No, I do on count 1, but on count 2, it's a capious misdemeanor, and for some reason, all these case numbers from North, they're not doing any of the PCs.
And I believe Mr. Arguda has information to share with the court in reference why he missed court, but having said that, Judge, I know on count 1, he does wish to resolve that matter, so if Your Honor does have the PC affidavit, we would be asking the court to consider resolving
No
count 1.
problem.
The offer on one would be withhold court
Okay,
costs.
withholding court costs, is that what he wants? If he wants to resolve it, it's not gonna get any better than that. So raise your right hand.
He wishes to accept the state's offer, Judge.
That's what I thought. He can't get any better than that.
Yes, ma'am.
Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Your name, Adam Argudo, Argudo?
Yes, ma'am.
How do you want to plead to resisting an officer without violence?
No
Guilty, not
contest.
guilty, no contest? Feel that it's
No
in your
contest.
best interest?
Yes, ma'am.
All right, ever been treated for a mental illness?
No, ma'am.
All right, court's gonna accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea, withhold, court costs $293. 6 months to pay, partial payments accepted. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Court takes judicial notice of time served in the Broward County Jail. Tell you what, I'll ROR him on count 2, but if you don't come to court, sir, then you're just gonna keep getting arrested again. Is your mailing address 40 Northeast 21st Court, Pompano Beach, where you get your notices? If that's no longer good, you can either give me an address or I can tell you a way to find out how to look for your court date.
Yeah, can I just do that?
Okay, so this is what you do if you go to the public library.
Okay.
It's free to get on the internet. You go to browardclerk.org. It's the Broward Clerk of Court. You put in your name, and it'll tell you when you have your court date, okay?
Okay.
You can also call Mr. Shate, who I'm gonna appoint to represent you in this case. So I'll ROR you, look for your court date, look for where the location, it could be at the Central Courthouse, could be back at North with Judge Hurley, okay?
Yes, ma'am.
All right, thank you, sir, good luck to you. Mr. Shake, do you have, can you give him your number? And do you want, I don't know, do you have a number, sir?
Yes.
What is it?
520-265-6832.
All right, I'm gonna appoint Mr. Shake. Thank you, sir, good luck to you.
Thank you, Judge.
Thank you.
Judge, next matter is Kevin Byrne on page 10.
Do I have that one? Yes,
No.
I do.
Judge, I wasn't able to speak to him. That may be Mr. Byrne sleeping in the back. They couldn't wake him up.
Second up with P.
Okay, I signed all your orders here, Mr. Shade.
Thank you, Judge. Good morning, Kevin.
Good morning.
Mr. Byrne, good morning. You have a capious misdemeanor. What's your client's name, Mr. Douglas?
It's Samuel Burnell.
Okay, hopefully we have him at the main jail.
No, he's at
He's supposed to be brought over. We told the deputy.
It's here by 11.
Kevin, would you like to try to get some help at the Central Receiving Center at Henderson Health Clinic?
Sure, yes.
Yes? Excellent. You'll be released tonight at 9 o'clock to there. Would you rather go in the morning or at night?
Tonight's fine.
Tonight's fine? Okay.
At Henderson? Is that what you said? Yeah.
Yes.
Thank you.
Give me one moment, Mr. Shade. My computer keeps working slow. Here's the thing. He has other pending cases. I'm not resolving it. I mean, he can't go back to this location. It's as simple as that, and he keeps doing it. If he I shouldn't say I'm not gonna resolve it. If he wants to do it, I'll do 5 days Broward County Jail, credit for time served, no return.
You hear that, Kevin?
Yeah.
Would you like, also after those 5 days, would you still like to go to the CRC?
Yeah.
Excellent.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Kevin Brine, B-R-Y-B-Y-R-N-E?
Yeah, it's Byrne.
Byrne, I'm sorry, sir. It's my understanding
okay.
through your attorney, Mr. Shate, you want to resolve your case today and give up your rights to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
Yes, ma'am.
Don't tell me what it is. Does your mental illness affect your ability to understand what's going on here today?
No, ma'am.
All right, how do you want to plead to the municipal ordinance violation of solicitation violation? Guilty, not guilty, no contest.
No contest.
Court's going to accept your plea, find that it's freely and voluntarily entered. court has reviewed the court file with probable cause, adjudication, 5 days, Broward County Jail with credit for time
It's not
served.
Sentinel, it's not
No
recognizing
return
her.
charge
It's one of
due.
my. Yeah, I have to write it all out. It's not getting me like any used to.
If you want to resolve, there's another case here.
Here.
But it's unfiled, I can resolve it if he wants, I don't know.
Yes, Judge, he would, so we don't have to come back. Probably another solicitation,
Sign out,
Kevin.
sign out.
Yep, 186139,
Sign out.
About hanging out.
MO 10A.
Oh, okay.
Yes, no? He doesn't have to, I'm just,
Kevin, would you like to resolve that case also, so you don't have to come back to court?
Yes, Matt.
okay, that's failure to wear an ocean vest and street solicitor violation. How do you want to plead to that?
No contest.
Okay, adjudication, time served, 5 days, Broward County Jail, credit for time served. That's with the no OSHA vest as well. That's obviously concurrent. Give me just one moment.
Excuse me, sir, will they come pick me up?
Yes, so they'll take you straight from the jail. It should be Monday morning,
No, it
Okay,
should,
thank you.
is it Monday or Tuesday?
the 12th. It's a Monday.
It's gotta be I don't know if they're picking up, we call them up and find out.
Okay. Or maybe not be Monday? Maybe Tuesday because of the holiday.
So then I have to walk there?
No. They'll pick you up regardless.
Okay, let's do a release, 11/13/18. So court's gonna accept his plea, adjudicate 5 days on both, Broward County Jail, $78 in court costs on each case. 6 months to pay, partial payments accepted, he has 30 days to appeal the sentence of the court. If he can't afford an attorney, one will be appointed.
11/13.
So they'll pick me up Tuesday morning?
Six days. Okay, so it'll be 6 days, so you can be picked up and go to the CRC. It'll be 9 AM in the morning, okay, sir? Good luck to you.
Tuesday?
Tuesday morning. Tuesday morning, correct.
Thank you.
Take
You're
care,
welcome,
Kevin.
sir. Okay, I put the case number here. It's MO 10A. You want me to do a printout? Let me do a printout for you. It'll be easier. Hold on. Okay, Madam Clerk, I'm gonna print it out for you so you have it, okay? So it's easier, you'll see the charges and.
Or at least we are. She's not. She lives in her country.
I believe that's all I have, Judge.
Thank you. See you at 1.
That's it.
I wasn't here in the afternoon. I had a doctor's appointment, so I wasn't here. Yeah, no, I was here. They started at 11 and you told me it went on for like 2
You might have another unfiled case, Mr. Shade, I don't know. So you might want to look it up when you get back to your office.
Okay, Mr.
If
Burns?
you want to bring him back, well, I'm not going to be here, so, but if you want to bring him back, if he is.
Okay, I'll
Okay?
see. I'll check.
Thank you.
She's gone now.
Okay, James Scott,
Judge, I have an update on Mr. Brunellis.
sure.
I called up to Conte. They advised me that Mr. Brunellis was sent down here for PM court.
Well, where is he?
I believe he's in transport. That's the impression I got. I don't know if he's available to appear by
All right, so
video.
I don't know what the problem is
He's
with.
here, he's here. He's here,
Because I
and they
talked to
will
him.
have him brought on.
Perfect.
Oh, okay, all right,
Beautiful.
good. Well, that's
There you
a
go.
pleasant update.
Thank you, mister, for letting us know. James Scott. Is that your
Yes, Your
name?
President Judge.
Okay, sir, you have distribute or deliver cocaine, $2,500 bond. Court does find probable cause. What say you?
Judge, he's financially indigent, he's homeless, he's
Mhm.
not working, he's 33 years old, there's no one that can afford to post a bond, he's asking the court to consider releasing him pretrial release.
I'm not gonna do that. He's charged with a second-degree felony, punishable by up to 15 years in the Broward, in the Florida State Prison,
It is the sale of one rock, Judge.
okay? I understand. What say you, State? $2,500 bond.
Yes, Your Honor. Mr. Scott, he has a drug paraphernalia he pled out from September 27th. Possession of PVP twice in 2015. Possession of cannabis with intent to sell or deliver at or near a school or child care facility, 2014.
Thank you, ma'am.
He is also a registered gang member. And that's the most significant of his priors, what I advise the court of.
Does he have a mailing address?
No, he does not, Judge.
All right. I'm not gonna require a bond, but I'm gonna do a GPS open schedule. He has to find a place to live. Thank you, sir. Good luck to you. Next one is Izell Jackson.
Mr. Jackson, come on up, please.
Mr. Jackson, you have,
Good morning, Your Honor.
good morning, sir. You have a touch and strike battery, $1,000 bond. Count two, possession of
Waive
cocaine.
formal reading of count 3.
Count two is possession of cocaine. Count three, you need to talk about bond. Court does find probable cause. What say you, State?
Your Honor, first, as far as count one, we don't have an alleged victim's name, but this business is a mobile gas station.
Okay,
So I'm just going to ask the court to order no return to that mobile and no contact with any of
no return to what?
the mobile gas station on 2701 West Atlantic in Pompano.
Okay, and maintain how many feet?
I'm fine with 500. And,
Maintain 500 feet minimum. Do you understand, sir?
Yes, ma'am.
and Your Honor, I would also ask that include no contact with any employees, so that would cover the no victim contact.
All right, that includes the sidewalk, the parking lot, and no contact with any employees of the mobile gas station. Or the owner, correct?
Yes, please, Your Honor. Let's see, 1, 2.
All right, what say you, defense?
Judge, Mr. Jackson is 61 years old. He's been here his whole entire life. Right now, he's not working. Unfortunately, he's homeless. Judge, he's financially indigent. I'd ask you to take that into account in determining reasonable release conditions for Mr. Jackson.
And, Your Honor, I'm going to be requesting a $5,000 bond on count 3. I would note the underlying offense that he is registered for was a 2008 case where he was sentenced to 10 years in state prison as a habitual offender and a PRR offender. It would appear that he... And I would just also note, and I know Mr. Romero is advising the court that Mr. Jackson's homeless. According to the report, when this was investigated, he had given First Step Sober House as his residential address, and
Then he moved out.
yes, that he left the program 9 days after getting there. So it would appear he did have a place to stay, but chose not to stay there. And he was released from state prison March 30th of this year.
Okay, anything further?
No, Judge.
All right, so the court finds probable cause on count one. Court will do $1,000 bond on count two. The court will ROR $1. Count three, the court will do $2,500 bond, no return to the mobile gas station, maintain 500 feet, no contact with employees or owner of a mobile gas station, GPS level 2.
Well, that's for $1 bond.
Pardon?
Dollar on 2.
Is on count 1 and 3. I'm sorry, 1, 2, and 3. Yes. Yeah, the cocaine. Sean Walton. Sean Walton, step up, please. Mr. Walton, you have grand theft auto, $1,000 bond.
Mr. Walton's here present, Judge. He declined the service of public defender.
Okay, Mr. Walton, you understand that if you can't afford an attorney, you'll have to fill out an application. But for right purposes of now, the court would appoint the public defender.
Okay.
Or you can represent yourself, or you can tell me if you have a private attorney. Which is it?
Well, right now, Your Honor, I go to court on Tuesday, and
All right, but we're here on the grand theft auto, sir, and the resisting it without. Which do you prefer? Do you want to represent yourself? Do you want me to appoint the public defender, or do you have a private attorney?
you can put the public defender, Your Honor.
All right, so let's appoint Mr. Romero. Have you had an opportunity to speak to your client, Mr. Walton?
Judge, I just know he's looking forward to going to court on the 13th.
All right, he has a grand theft auto, $1,000 bond. Count two is resisting an officer obstructing without violence. Counts 3, 4, 5, 6, 7, 8, 9, 10 are all no bond holds. They're warrants for violation of pretrial. Do we have any victims' initials in this?
One moment, one moment, Judge. No, Your Honor, does not appear so.
All right, so I can't say any no victim contact. All right. So $1,000 bond on one, unless I hear something different.
Judge, Mr. Walton is asking me to request an ROR on count 1.
Not gonna ROR him. He has all these violations of pretrial. He also has a pending case. He was also arrested by Boca Raton Police for the offense of violation of an injunction for domestic violence. Court's gonna leave the bond at 1,000. Count two is no charge, which means no bond required. Thank you, sir. Good luck to you. Joshua Pitts?
Come on up, sir.
No, that's why I missed it.
Oh. Yeah, well, you should have told me to wait. Joshua Pitts.
We waive formal reading on counts 2 and 3.
All right, Mr. Pitts, you have 3 charges. Count 1 is petty theft, second degree, first offense, $25 bond. Counts 2 and 3, sir, you need to talk about bond. Court does find probable cause. Court is gonna order no return to the Walmart at 2500 West Broward Boulevard, Fort Lauderdale, Florida. If you go back there, sir, you will be arrested. What say you, state?
The change of charge. One moment, Your Honor. We'll take care of it real quick. It'll be easy. Hold, just give me a second.
Person after this is gonna be Ernesto Montamer, Arnold Pubian, Leray Kemp, and then Michael Glazer.
Your Honor, I'm gonna be requesting, $5,000 bonds on counts 2 and 3.
Okay.
Just to advise the court, the underlying offense that he's, registered for was in 2008. He violated probation and was sentenced to 8 years in state prison.
Okay. Anything further?
Judge, unfortunately, at this time, Mr. Pitts is homeless. There's no one that's gonna be able to afford any sort of monetary bond. He's 46 years old. Right now, he's currently looking for employment. So Judge, I'd ask you to take that also into consideration, determining a reasonable release condition.
All right, court finds probable cause, no return to Walmart, $1 on count 1, 5,000 on 2, 2,500 on 3. Thank you, sir, good luck to you. Next one is Ernesto Montana.
He bonded, Judge.
Thank you.
Mr. Pubian?
Arnold Pubian. Pubian did?
Okay, cool.
Okay, Pubian, his bond posted. Thank you, sir, good luck to you. Leray Kemp.
Mr. Kemp, come on up, please.
All right, Mr. Kemp, you have possession of MDMA, ecstasy. What seems to be the problem there? Okay, you have possession of MDMA, ecstasy, $1,000 bond. Count 2 is warrant for violation of pretrial for a felony. He has a no bond hold. He is going before his division judge, Judge Marina Garcia Wood, on Wednesday at 10:30 a.m. or Thursday. What day is the 15th? On Thursday, I'm sorry, at 10:30 a.m. on his violation of pretrial. Court does find probable cause. Bond set at $1,000. Thank you, sir. Good luck to you. Did he tell you what page? Who do you have?
Good morning, Your Honor. Last turned off Mike Gottlieb. Devon Edwards.
What page?
Mr. Edwards? Devon Edwards?
Okay, let's bring up Mr. Edwards.
Your Honor, just to let you know, I spoke with, Mr. Strandell. I believe we have, agreed upon bond amounts.
Okay, you wanna, pardon?
Conti.
Conti?
Conti.
Hello, sir. Are you Mr. Edward Devon?
Yes, ma'am.
All right, sir. You have add charges. Do you see your attorney here?
Yes, ma'am.
You waive reading?
Yes, Judge.
All right, so court finds probable cause. What say you, state or defense?
Your
Tell
Honor,
me what's happening.
we've come to an agreement of $1,000 bond on the battery law enforcement officer and
The
$100.
firearm is,
or the-
carrying concealed firearm is 1,000, 100 on resisting without violence, 100 on the DWLS. He's county sentenced, Your Honor, so he's gonna be in for a little
All right,
while.
I'll do $1 on 1 and 2.
Thank you
I
much,
mean,
Judge.
So we'll do 1,000 on the carrying concealed. The other 2 will be $1 each.
It's fine.
Thank you
Okay?
very much, Your Honor.
Thank you.
Good
Have
to
a
see you.
great day. Michael Wayne Glazer, please. Michael Wayne Glazer, Main Jail. Mr. Glazer, you have failure to redeliver hired vehicle. Court does find probable cause. There was a warrant to arrest, bond set at $2,500 by Judge Marina Garcia Wood. Court's gonna also order no return to the Enterprise Rent-A-Car. What say you, defense?
Judge, asking for the court to consider releasing Mr. Glazer ROR, and this is the reason why. My understanding, Judge, is he had a vehicle. It was in an accident, and basically that's where he obtained the vehicle through Enterprise. He has all the documentation going back and forth between Enterprise, their communications. My understanding is eventually his own insurance company that initially he used to help him rent a vehicle because his vehicle was under repair was Ocean Casualty. He has the paperwork that Ocean Casualty already paid off the entire bill with Enterprise. He's 61 years old. He's right now working. He works for a company called Tebow Advisors. Right now, he's just been working there for 2 weeks. They're with like an open enrollment with healthcare, and that's what he's doing. He gets paid about $300 a week. He lives here local. And my understanding is he has a limited contact with the criminal justice system, and that's why we're gonna be asking for an ROR on this non-violent offense, Judge.
You can let them in, no big deal. Yeah, let them in, no problem. Hi, I called you back, Mr. Goldberg, this morning. All right.
I wouldn't call his contact with the criminal justice system limited. In Florida, he has 6 prior felony convictions, 13 prior misdemeanor convictions, 3 prior failures to appear. I'm getting hits out of New Jersey, Texas, New York, and Pennsylvania. And at the end of the day, I don't know about Mr. Glazer's insurance, but according to this, he was supposed to return the vehicle in June. It wasn't returned. This warrant was signed August 30th.
All right, Jackie, I need you to come up for a moment. Just give me one moment, we're gonna go. Just tell them 5 minutes, okay?
Judge, before I proceed also, it was my mistake. I used the term limited contact. Mr. Glazer did not tell me that. That was my mistake. He advised me that in 2014 was his last prior contact with the criminal justice system. So I didn't want the court thinking that he misrepresented any information. It was actually my mistake, Judge.
All right, $1,000 bond, no return to the enterprise rent-a-car. Thank you. All right, welcome.
She ordered pretrial through GPS.
Well, Alex, ALAHLF. Come on up, sir. You have 2 capias.
Present, Judge.
Okay, you have 2 capias misdemeanors, which are possession of drug paraphernalia, failure to register a vehicle. Count 3 is a capias felony, possession of cocaine, no bond hold. That's a warrant for a wait. 3, I'm sorry, possession of cocaine. No bond hold is actually not for magistrate, signed by Judge Bailey. Count 4 is also a no bond hold. 5 and 6 violated your pretrial conditions, so you have no bond holds for that as well. You're going before Judge Bailey this coming Tuesday at 8:30 a.m. You're going to be held no bond, and then the next day on 11/14, which is Wednesday, you're going before Judge Pohl on the 2 capious misdemeanors. Court does find probable cause. I'm going to leave your bonds in place on the capious misdemeanor. It's $1,000 on 1. ROR on 2. Thank you, sir. Good luck to you. Next one's going to be Charles Sanchez, please.
Mr. Sanchez, come on up, sir.
Mr. Sanchez, you have possession of cannabis over 20 grams, sir. $1,000 bond. Count 2, distribute, deliver cannabis, $1,000 bond. Count 3, drug paraphernalia, possess and/or use, $100 bond. Total bonds $2,100. What say you, Mr. Romero?
Judge, I'm going to be asking for the court to consider releasing him ROR, and this is why. He's 23 years old, been here his whole entire life. He's working. He works for a company called Bullis Land Surveyors.
All right, does he have any prior state? Do you object?
I don't object.
All right, ROR. Thank you, sir. Good luck to you.
Good luck, sir. You should be getting a notice probably in about 30 days. Okay, make sure you come back to court.
Andre Rest. This might be a little out of order. Is that still a medical?
Right now, Judge, yes, it looks like he is still a medical loan.
All right, we found PC previously.
Yes,
Alan
we did.
Zalea.
I believe that's the same situation with Mr. Zalea.
Okay, medical loan on Zalea. Craig Fainer.
That is a medical reset.
Medical reset. Thank you. Tony Johnson.
Main jail.
Mr. Johnson, good morning,
Hey,
sir.
Mr.
Hope you're
Johnson's here
feeling
present,
better. You have a touch or strike battery, $1,000 bond. Count 2 is battery on an officer firefighter. We need to talk about bond. Court is going to order no return to the Pompano Beach Sandbar Snack Shop. What say you, state? What are you requesting for bond on the battery on a law enforcement officer?
One moment, Judge. Your Honor, I'd be requesting a $2,500 bond on the battery law enforcement officer. His criminal history, drug paraphernalia from earlier this year, 2015 possession of cocaine with a VOP, 3 years in state prison, 08 aggravated assault with a deadly weapon, 28 months in state prison as a habitual offender, 04 felony battery due to priors, VOP, 17 months state prison, primarily drug priors before that, Judge.
All right, what say you, defense?
Judge, unfortunately, Mr. Johnson, there's nobody that's going to be able to afford to post his monetary bond. We're going to be asking the court to consider releasing him on pretrial release. He is homeless, Judge. He's 47 years old. He does have a mailing address. It would be of St. Lawrence, where he's allowed to receive correspondence from there. So he would know as far as his future court notices. He's looking forward to coming to court and contesting these allegations, Judge. He does get help. He gets food stamps. But right now, financially, he has no money in the bank. He has no sort of assets, no sort of property. Judge, he wishes to fight these allegations on the outside and not being forced here in jail in order to account for these allegations. So, Judge, I'd ask you to consider releasing Mr. Johnson on pretrial release.
Anything further, state?
No, Judge.
All right, court's going to do 1,000 on 1, 2,500 on 2. No return to the Pompano Beach Sandbar. No victim contact, direct or indirect, with Terry Delmarsh. Thank you, sir. Good luck to you. Next one is Luis Quinones.
It's going to be up just a minute.
Luis Quinones, step up, please.
Paul Ryan, Your Honor.
Paul Ryan. Mr. Quinones, good morning, sir. You have possession of a firearm by a felon. This is a change of charge, count 9. You have a no bond hold for magistrate. Court does find probable cause. What say you, state?
Your Honor, bond was originally set at $2,500. I'm just checking to see what, if anything else, he's being held on.
Mr. Quinones has no bond holds on a number of counts, Judge. I'd ask for a $1,500 bond.
$2,500 bond. Thank you, sir. Good luck to you. Jamarcus Rogers.
Main jail.
Main jail.
Mr. Rogers, Jamarcus Rogers?
Yes, sir.
Hold on one moment. He's on page 26. I'm trying to locate him right now, Judge.
All right, let's pass him while you're locating him. Sean Whitehead.
Mr. Whitehead is here present, Judge.
Come on up, Mr. Whitehead. You have an aggravated battery, caused bodily harm or disability, $5,000 bond. Count 2 is false imprisonment, an adult. Court does find probable cause. Total bond is $12,500. Court is going to order no victim contact, direct or indirect, with the alleged victim with the initials MFV. And I'm going to require you maintain 1,000 feet minimum from this person. What say you, defense?
Judge, in speaking with Mr. Whitehead, he's looking forward to contesting these allegations. However, having said that, at this time, nothing to request on Mr. Whitehead's behalf.
All right, 5,000 on 1, 7,500 on 2. Maintain 1,000 feet minimum, sir. I'm also going to do a GPS level 2 on count 1 and 2. Thank you.
Judge, Michael Russ on page 26.
Yes.
They're wanting to know if we need him. It says it's a warrant for a violation of pretrial release, but there's no
What's
bond
going on
amounts.
with that?
Your Honor, if I can give you some paperwork,
Sure.
please. This was actually a mistake.
So what is it?
No, it's here. I try to give you this documentation. before I can
Okay.
explain. Your Honor, as you can see, and I've provided you the printout of the register of actions from the clerk system. Everything, just so you know, everything I got there, I got off Odyssey, but I can,
I think you should take a look.
Your
So
Honor.
why don't we do this? Do you want to reset them?
You know, Your Honor, I can explain this to Mr. Reed in just a minute.
Okay, show them the paperwork. What?
Cycle in
Okay.
once this group's done.
All right.
So,
Well, this is the thing, I gotta let the extradition person in.
sure. Do you want the class to be in here for that, or would you
No,
prefer them
because
to
we
be out?
move everybody, we have everybody stand there.
No problem. We'll clear them out, Judge.
Okay.
I understand. Are they ready?
I'm gonna do these, we have a couple more, I'm gonna finish this before
And then
we
we'll
do, because we have some medical resets and stuff, it'll be pretty quick.
Okay.
Okay, where's Michael Russ?
He is in the place that just called me, which is, I think, Paul Ryan.
Paul Ryan. Okay, go ahead, Mr. Linder, I'm not asking you to rush, but.
No, I can
Speed
get,
it
I
up.
think, yes, ma'am. Your Honor, Mr. Russ was originally arrested for molestation.
Okay,
And I provided you we first did a change of charge
Okay.
to battery. If you
Okay.
look at the filing instructions, it still says molestation.
yep,
But he was arraigned at a later date for the battery.
okay,
He was given pretrial. He ended up violating pretrial. Judge Merrigan did a no bond violation of pretrial.
okay,
We then did, when we realized that the filing instructions had the wrong charge, that it didn't match the information, we did an amended filing instruction solely to reflect the correct charge. I provided you a copy. If you look at that, there's a specific instruction to the clerk. Do not issue a capias based on this. It's just meant to reflect the correct charge.
talking about this?
Yes, ma'am. So this change of charge capias that he stands before you on should have never been issued.
All right, so is he here today? Do we have to magistrate him on this?
Your Honor, I do not believe so because,
All right, you want me to delete him from the docket?
yes.
Yes, he has Mr. Russ, you have a court date on Tuesday with Judge Merrigan, okay?
All right, attach this paperwork,
Okay,
Madam
all right,
Clerk.
good luck.
Delete him
Good
from
morning,
the docket.
if I may, Judge, I'm sorry. Erica Hernandez on behalf of the state. I'm actually the prosecutor that began this process to correct this on Odyssey. Defense filed a motion to reinstate the bond, so I wanted to make sure the accurate charge reflected in Odyssey. That's why I did that.
All right.
But
so-
nothing needs to be done. It's gonna be handled in Judge Merrigan.
Thank you.
Thank you, Judge.
Thank you. Curtis Plummer, step up. This was 48 hours to perfect.
How you doing, man?
It's,
Yeah.
Your Honor, it should just, we got a supplement, but frankly, just looking at this should be, hold on one second.
You want me to ROR, no PC? Or are you
Well, no,
saying
Your
it's
Honor,
grand theft?
Your Honor, I'd ask you to find I'm just looking at this supplement real quick.
He took two
This is the
bottles of
supplement right
vodka, of Patron vodka, so it's gonna be
Changed it to this.
It should
petty
just,
theft.
it should just be petty theft or subsequent, Your Honor. Whatever you want to do with the bond, frankly, is fine with me because
I'd ask for a dollar bond, Judge.
Dollar bond, PC for third subsequent offense.
All right, Curtis, you're no longer charged with stealing 2,000 pieces of fruit. It's 2 bottles of Patron instead, okay? But you got some other things pending as well, so good luck to you.
Could I ask you a question before I leave?
Yeah, let me call you.
Would all of it be in Usan courtroom, or I have to wait, or?
Yeah, you're gonna have to go in front of Judge Usan. Let me see if I've got a date for you.
Okay, John Foltz, where's he? We're gonna come back to you, sir. John Foltz, where's he? All right, we're gonna have to reset him. I don't know where they are from the city.
He's got a couple of municipal ordinances and a misdemeanor, Judge.
All right, let's reset him for 1 PM. Mr. Odom has to come on him. Go ahead, you can finish with this client. I'll tell you what, Mr. Reedy, call him on the phone, because I want to keep going, because we have.
No, I hear you, Judge. I don't have a date for you right now, Mr. Plummer.
And Judge, I have additional information on that gentleman that you had on recall, Mr. Jamarcus Rogers. He's in court in room number 5810.
probably on this.
Yes, he has some no bond holds on him as well, Judge.
All right, let's just reset him for tomorrow, Mr. Rogers. Alicia St. Sierra,
Alicia, Mr. St. Cyr is here present with us at Main, Judge.
And the issue on this, Judge, was the probable cause affidavit did not reflect a distance in feet
from the school.
from the school to where the incident, where the sale of the narcotics took place.
Yes, I remember. Do we have it? How many feet? Within 1,000 feet of a school? Within 30 feet from the school property, which
Doesn't
I
say,
gathered.
it doesn't say that how this was measured, or who measured it, or what device was used, or anything like that. I would still maintain that this is insufficient to establish probable cause.
Court's gonna find probable cause. What say you with regard to the three bonds, 7,500, 5,000, 7,500?
Judge, if my math is correct, that's a total of $20,000.
Yes, sir.
Also, in reference to counts 1 and 4, I believe the court imposed a $9,000 plus level 2 Elmo on Mr. St. Cyr's behalf. His family's going to have a tough time posting that bond as it stands, Judge. He's 31 years old, been here 27 years. He is working. He works at a tire shop, been working at the same tire shop for about 2 years. On a good week, he can make up to about $500 a week. Fortunately, his wife works as well, and she works at Pride AC and Appliance. She's been working there for 5 years, making about $16 an hour, and both of them are supporting their 3 children. Judge, right now, as it stands, like I said, they can't post that monetary bond. I'm going to be asking for bond reductions on 2, 3, and 5 from a total of $20,000 to $5,000. I would have the breakdown be $2,000 on counts 2 and 5, and a $1,000 bond on 3. There would be, if you add it all up together, 5,000 plus the 9,000 that was currently set yesterday, that would be a total of $14,000. We'd be asking the court to consider also placing him on these level 2 with Elmo. I believe that would be reasonable under Mr. St. Cyr's circumstances, considering his strong ties to community and his financial resources.
And the court had placed him on pretrial Elmo.
I have it.
Okay.
Okay, this is what the court's doing. With the possession with intent to sell, manufacture, deliver within 1,000 feet, specified area, 2,500. 3 is 22,000. Sell cocaine within 1,000 feet of a school, childcare, or park, 2,500. GPS open schedule. So he'll be on the open schedule with all of them.
I'm sorry, Judge, what was 3?
3 is 2,000, 25, 2, and 25. Thank you, sir. Good luck to you.
Thank you,
Deshaun,
Judge.
and the court finds probable cause. Deshaun Walker, please.
That's another
That's a change of charge.
Who is that on? Okay.
Maureen Gale? Yes, it is. We're gonna reset to 1 o'clock. Thank you, good luck. Bye. Justin Smith.
Where's your docket?
Justin Smith.
You don't know your docket.
Does anybody know where Justin, oh, that's an MO too, we're gonna reset that. All right, so we're done with this. We have, hello, sir, how are you? Yes, ma'am. All right, so these MOs, we're just gonna reset. And this goes with that drug one, with the school. Is that an MO? Oh, reset till tomorrow.
You better take the centerpiece.
Yeah, he's in 5810.
For all that 9 hours of driving, you better take one of
And that
those.
probable cause goes with the
Get
one
something
that I
back
just
out of it.
did.
Who's going?
Yes, 1,500, 2,000. That was just for
Moose?
the
So
perfection.
how does Moose, this is such a cultural thing, because in our.
All right, so we're finished. Anybody else?
He is avoided.
Anybody else?
I don't know.
All right, so we're gonna go to our extradition docket today.
One thing on Wendy Riley,
Yes, sir?
I spoke with the folks over at the Eaton House for Women. They want to know if you
It's not about us releasing her, they have to pick her up.
Yeah, it's kind of.
will, but they want to know if there's a time.
She's got a.
We'll ask Sheila. Sheila can give you a good time frame. What time can we tell Healing House to pick her up? 5 o'clock?
Wendy Riley.
She's GPS? When can you get her outfitted with the GPS?
She has to be brought over to the, was she going, was she at the main jail or no? She's at Paul Ryan. She has to be brought over to the main jail, so it's gonna be a while.
So give us a time, 7 o'clock? 8 o'clock?
I understand, don't they normally call confinement and set it up with confinement when they're gonna pick her up?
No.
I thought, all right,
Did you
that's
do
what
an
I thought.
order for her to go custody, or she just living there?
I can do that.
No. He can come, if that's where she's going, they can come pick her up whenever she is. You don't need a certain.
Did I do a GPS?
It's not gonna be a certain time because her body has to be brought over. So she can.
I did a GPS, so it is custody. Unless, you know what? That's what I want.
But they want to know if there's a specific time when she.
Tell them after 8 o'clock tonight. That should be sufficient time. Put it in the order.
Reset till 7.
And that's been confirmed. Ms. Patrice? Been verified then. Okay, is there anybody else? Mr. Reedy, anything else?
No, I think that's it.
All right, see you soon.